I think we can start. So very welcome to this conference. This is the third conference of its, not quite of its size. It started out as a colloquium for 2 years. So this is now the first official annual conference on corporate and financial markets law. And for us to just do the welcome and the opening, it pleases me to hand over to our Executive Dean, Dr. nwu-pukke. The floor is yours, man.
Thank you, Prof. Kaneli, and good morning, ladies and gentlemen, colleagues, guests, students, and our participants. It is my pleasure to welcome you all to the first Corporate and Financial Markets Conference 2021. I welcome all the eminent speakers, researchers, scholars, guests, and the students. The theme of the conference is Confronting the Effects of COVID-19 Pandemic on Corporate Governance, Corporate Insolvency, and Financial Education Measures in Practice. You have come to share your knowledge and your experiences, and I hope you will engage in an open and constructive dialogue. And as a faculty, we are greatly honored to host this August event and indebted to Prof. Howard Chitimira for this initiative. I sincerely hope you will enjoy the debates and networking for the next 2 days. I wish I could offer you virtual coffee and some lunches, but be that as it may, thank you for your participation, and you are welcome.
Thank you very much, Dr. Naya. And ladies and gentlemen, that brings us immediately to the first session. And it is my great pleasure to introduce to you Professor Jean du Plessis. Now, I must say that he is a South African. And so most of the people here from South Africa will know him. He's currently a professor in corporate law at Deakin Law School at the Deakin University, where he teaches corporate law and corporate governance. You can see in the program his career highlights, but it's interesting. He got his doctorate in 1991 at the University of Johannesburg, where he was professor of mercantile law before he abandoned us for Australia and better rugby and cricket teams, sadly. And he does a lot of research, not just in Australia and South Africa, but also in the UK and Germany. He's the recipient of the Anneliese Meyer Research Award from the Alexander von Humboldt Foundation. And he is a man known throughout the world as a serious academic who writes an awful lot and influences the law in his area. So Jean, welcome to this conference, and we are really looking forward to listening and hearing what you have to share with us this morning. So thank you very much, and the floor is yours.
Thank you very much. I've just put the timer on here because I don't want to disappoint you and go long over the time. 20 minutes. I begged Professor Chitimira for 40 minutes, but he bluntly refused my kind request, so I'll stick with my 20 minutes. I don't know whether I should start opening by Madam Chair or whatever, but I would like to say, ladies and gentlemen, I'm really, really pleased that I can participate in this conference. It's really wonderful to be able to open it for you with the opening keynote address, and I hope I do not disappoint you. I would like to start by sharing with you, if my PowerPoint, I just want to click here, will continue, something from down under. Here in Australia, when we open any significant meeting or any gathering, we always start it with acknowledging the traditional custodians of the land on which a meeting or gathering takes place, and paying respect to the elders and past and present. Now, it would be incredibly difficult, if not impossible, for me to find the owner of the web and to pay my respects and to acknowledge the owners of what we are using here today. So in a world where we live on the internet, it's really difficult to acknowledge somebody in particular. But I thought it would then be appropriate to at least acknowledge and thank Professor Howard Chitimira. He is the driving force and the leader who convened this wonderful conference. And I really think that all of us were and still are very much impressed with the meticulous way and the energy in which he convened this conference. And I would really like to congratulate him. I've done many conferences and I know the amount of work that's going into this. So with that, thanks and acknowledgement to Professor Howard Chitimira, I would like to start my address. I wanted to remind myself what a keynote address is all about. And I found this definition, I found many, but the one that I really like is an address. A keynote address is an address designed to present the issues of primary interest to an assembly, such as a political convention, and often to arouse unity and enthusiasm. Now, it's definitely not an assembly, it's a conference. It's definitely not a political convention. I don't want this, I hope for your sake that it will not turn out into a political issue. But what I can do, I can hopefully mention some of the issues of primary interest in the area of the conference theme. I would find it very difficult to arouse unity because unity nowadays is a very, very rare phenomenon. And it is probably best illustrated by the disunity caused by the debate on to be or not to be vaccinated against the COVID-19 virus. I'm sure you are also involved in that disunifying debate in South Africa. But I hope that at least the other thing that I can contribute, apart from raising the issues of primary interest, is hopefully to arouse some enthusiasm, because most of you who know me would know I'm incredibly enthusiastic about my subject area, and not only corporate law and corporate governance, but also from an international perspective. And in that sense, I hope that I can bring some enthusiasm for you. Now, what are the issues of primary interest for purposes of this conference? I really think that the conference theme, the program, and the exciting topics to be covered is really of primary interest to everybody interested in this broad area. So congratulations once again to Professor Chitimira for bringing together all these different individuals and all the wonderful, exciting topics. I think it's also for purposes of the South African audience. In particular, I've invited several of my colleagues from different other jurisdictions as well. But for purposes of the South African audience, it is, of course, very important and of primary interest, the South African Companies Act 7-1 of 2008, as it forms a very solid and flexible legal basis for refinement if you want to do the refinement. I'll say something more about your Companies Act in a minute. And then, of course, who can escape the consequences of COVID-19? The interest of it, the impact of it is just so immense. It's just beyond belief. It would have been beyond belief if you 3 years ago said that we will go through this traumatic situation with COVID-19. And I think that probably you've seen all the media coverage here in Australia. They've locked us down. I've just listened to a video this morning where they said the Americans should rather invade us here in Australia and free us from this absolutely shackles around us. Yes, the lockdowns are in actual fact or have been lifted, but in any case, we've been through a very terrible time. Whether you agree or disagree with it, and whether I agree or disagree with it, I will not go there for the moment. I am very much in favor of being vaccinated, and I've got both my vaccinations already. And then in order not to overwhelm you completely and make you totally and completely overwhelmed by what I'm going to say, I will eventually summarize and make 3 keynotes on my keynote address. But let's just spend a few minutes on the conference theme, the program, and existing topics to be covered. First of all, the impact of COVID-19 on corporate law and financial markets law. It's incredibly appropriate and very, very significant. And it's so good that you've spent some time over the next 2 days to focus on it. I also like the international perspectives that you will most definitely get through this conference. I see the names of Namibia, where I grew up. I see the names of Nigeria. I've got a student from Nigeria, and then several other countries that I'm sure you will have exposure to and have interesting debates on issues related to corporate governance, COVID-19, corporate law, and financial markets. And then, I mean, the 12 sessions with the wonderful themes that you have in the sessions, I'm sure it will allow for penetrating discussions and dissecting core corporate law and corporate governance issues. Indeed, when I saw the program, I envisage really a feast that's ahead of you. This very large table, a smorgasbord that you've got in front of you. It's just there to enjoy, and I am sure everybody would find something that would suit their taste. The vegetarians, the vegans, the carnivores, and I mean, even on the other ends of the dietary needs in a scholarly way. I'm sure you all will be satisfied if you indulge, and I would encourage you not in the actual smorgasbord, but in the spread on your table here to indulge and enjoy the 2 days of this conference. I would seriously like to suggest for the South African audience that you do not and should not try to reinvent the wheel and try and change your Companies Act fundamentally. You've got an absolutely incredibly modern Corporations and Companies Act. It's been revised extensively from 2002 till 2010. And I cannot help but to mention the name of my good friend, Professor Tsepo Mongalo, as well as Professor Dennis Davies, Astrid Luden, and Philip Knight, who really were driving forces with the international team of which I was part, that really spent a lot of time and energy on this. Phil Knight, the drafter, was just incredible. And I can just tell you, I think that you have got a very modern Corporations Act with unique aspects. And all the points that I make under point 1 are unique aspects of the South African Corporations Act. It's aspects that's been debated and refined, and I think that you will find it really very interesting to compare it with other jurisdictions. The King reports, of course, are significant. You would know that it started off in 1994 with Professor Mervyn King as the driving force, and I'm very proud to say Professor Mervyn King is also the recipient of an honorary doctorate from my university, Deakin University. I'm very proud of it. And Professor King has not only been a great example for me, but he's such an incredible driving force, such an example, such a high-profile person internationally, that you are incredibly fortunate to have such a person. And then, of course, you are also very fortunate that in South Africa, the South African courts embrace the concept of looking at the corporate governance code and use that as a guiding principles to interpret your law. I hope you appreciate that that's not the case in all other jurisdictions. In Australia, it cannot be used to interpret the legislation or the Corporations Act, and therefore you are very fortunate. I had a very quick exchange with Elena Stoop. I hope that's the correct pronunciation. I pronounce spies as, or spies as spies here in Australia. And I think the international audience wouldn't know how the words aren't necessarily pronounced in South Africa. But I think the pronunciation, Helena Stoop, would be appropriate. We had a short exchange and she wrote her PhD thesis on the application of corporate governance code and the interpretation by the courts. And I'm really looking forward to look into it in greater detail. Please attend that session. It's this morning, I think 10:50, and I think you will enjoy that very much. I want to let you once again take a moment to think what you have in South Africa. You have an approach that's been adopted by the King Report. And that approach adopted by the King Report would in actual fact be used by the courts to interpret your Corporations Act, as I've just explained. And I'm not going to take you through the whole quote there, but basically the King Report adopted the approach that the company is considered to be a separate legal entity and directors owe their duties towards the company as a separate legal entity, not towards the individual stakeholders. Not, and I please want you to take note of this once again, perhaps you know it, but in other jurisdictions it's a little bit vague. They do not owe their duties or fiduciary duties or duty of care and diligence towards the shareholders. They do not. It's law in South Africa that as part of taking into consideration the best interests of the corporation, they need to look at the interests of the various stakeholders that can vary from time to time. And they need to consider whether it's the workers, whether it's the community, whether it's the shareholder, whenever decisions are taken, your directors must, in actual fact, take into consideration their duties to the corporation or the company as a separate legal entity when they consider individual interests. They can at times distinguish and give an advantage to one particular stakeholder, but that should only and could only be done if it is in the best interest of the corporation as a separate legal entity. I want to just very shortly deviate quickly by way of a compliment. I just looked at your the South African Companies Amendment Bill that's at the moment going through Parliament, and I'm really very much impressed with it. I really think the general approach, and probably it is your Minister Ibrahim Patel, that should be complimented. I really love the way in which you approach the reform there. The philosophical pillars that's been explained in the explanatory memorandum, the very clear reasons and objectives of what you try to achieve. I just find it absolutely wonderful. And I wish that all legislatures would approach reform in that particular way. I do not know all the politics behind this. I know there's a lot of debate going on, and I've been part of the debate on putting employees on your unitary board. I'm against that. I'm very much in favor of protecting the interests of employees, but not through employee representation on the unitary board model. I think you should also appreciate that to a large extent, South Africa has been ahead of the pack. It's only in 2018 that the US started to embrace the all-inclusive stakeholder approach. So in South Africa, it's already been adopted, and because of Professor Mervyn King in 1994. So South Africa, to a large extent, has a head start of about 14 years. And if you start to look at the embracement of this all-inclusive stakeholder approach in America at the moment, you can just start off by looking at the letters that Larry Fink would send out to his CEOs of the corporations in which BlackRock, probably the largest investment company in the world. In 2018, in his letter, he said society is demanding that companies, both public and private, serve a social purpose. To prosper over time, every company must not only deliver financial performance, but also show how it makes a positive contribution to society. Companies must benefit all of their stakeholders, including shareholders, employees, customers, and the communities in which they operate. The dominance of shareholder primacy, profit maximization for shareholders were absolutely dominant by the time that he made the statement. He continued with his message in 2019 to the CEOs, and he said that companies must ask themselves, what role do we play in the community? How are we managing our impact on the environment? Are we working to create a diverse workforce? Are we providing the retaining and opportunities that our employees and our business will need to adjust to an increasingly automated world? And then also, do we cater for the needs of our workers or employees when they retire? And then, probably based on the impact on which the letters of Larry Fink had, the very influential American Business Roundtable made a very significant statement in 2019, where they embraced for the first time the all-inclusive stakeholder approach rather than the shareholder primacy model. And here they mentioned all the parties, all the stakeholders that I have mentioned: customers, employees, suppliers, the communities. And what I have added, the next part, the employees or the customers who generate business and allow for profit making. It's not their words, I've added it. The employees who manufacture goods and provide services to the company. The suppliers who supply goods and services to the company, and the communities in which we work and can be severely impacted by the companies. And then the shareholders, of course, very important, who provide part of the financial capital that allows companies to invest, grow, and innovate. So in 2020, and dealing with the year 2021, Larry Fink once again mentioned the importance now of COVID-19 and of the whole impact of climate change very, very prominently. But I think it's worth its while for us, I've got about 3 minutes left, to just for a moment, even though that is what he said, just listen to what his general message was also regarding shareholders or other stakeholders. And it's only a minute, and I hope you can hear me. Marita, if you can't, if I play, just let me know, but I think you would be able to hear. Just listen to this minute.
I really believe the transformation of leadership, the transformation of businesses is about more and more leaders, and they're focusing on things about their stakeholders. They're connecting with their employees deeper and broader. They're connecting with their clients broader, and they're certainly trying to be more connected to their society. So much of that is in this letter. It is about moving forward on better disclosure, more complete disclosure, especially on net zero. Climate change and investing is something that is a powerful economic result. As we move towards a more sustainable world, it's going to create great jobs. It's going to create a great environment. And so we should not be frightened of it. We should all be embracing it and finding ways that we could, be a part of that. And I think this is one of the big messages in the 2021 letter.
Right. I can hear somebody's microphone that's on, but perhaps it's only me. So I would just suggest the person would switch off the microphone for my last few slides. I would like to point out that since the 1970s, unfortunately, there's been a huge change regarding profit sharing. It deals with the very, very, very fundamental concept nowadays, capital allocation. And I would like you to please have a look at George Dallas's explanation as part of the Harvard Law School Forum on Corporate Governance as to how corporate capital should nowadays be allocated not only to the advantage of shareholders, but also to other stakeholders. And over time, and especially over the last 15, 20 years, the areas that really cause considerable concerns regarding the capital allocation dealt with excessive executive and director remuneration, the disproportionate percentage of profits or tax savings distributed as dividends to shareholders, and then the astronomical amount spent on share buybacks by the companies. This is in actual fact something that's of great concern, and Andy Haldane, the former chief economist of the Bank of England, pointed out how in the 1970s, only 10% of the company's capital was spent on the shareholders or profits, and 90% were reinvested back into the corporation. And in 2015, that changed to 65% to the shareholders. And on this particular graph, you've got a comparison between buybacks of shares, dividends, and capital expenditure. And you would be able to see that in actual fact, there's a huge discrepancy and something is wrong. And COVID-19, in actual fact, accentuated the problem here. My alarm will go off in a second. So I want to make this point, and this is my final few slides, that something is wrong, that the percentage that we spend on shareholders is disproportionate on what is spent on the other stakeholders, and something drastically will have to be done by it. Fortunately, COVID-19 accentuated the problem. This slide is real figures in Australia. In the years 2018 and 2019, two brilliant academic assistants collect the information for me. These were the percentages and the amounts spent respectively on remuneration of directors, dividends, and share buybacks. And since the COVID-19, this issue attracted the attention very prominently by very many international organizations. And what I've highlighted there, and I will make all my slides available, is the concern that governments and corporations or institutions had about dividend payouts, executive direct remuneration, share buybacks, and all of them encouraged for companies to reconsider because of COVID-19. But seriously, it should not have been only because of COVID-19. It should have been done based on what's fair, what's right, what will be in the best long-term and sustainable interest of a corporation. And that is to look after the interests of all your stakeholders, not only your shareholders. With this whole COVID-19 pandemic, it's no wonder that the employees came up in arms. They were not happy because after long years of prosperity, they were left in the cold. And if you want to read some fascinating theoretical models as to what the problem is and what the solutions are, please have a look at the work of Leo Strine, the former Chief Justice of the Delaware Supreme Court. You can make whatever you want about my clip art there, but what a problem, or what is definitely a problem nowadays, or what our problems are, and this is my theme of my address. What are the viruses? In my view, the viruses that we have that will probably lead to the demise of capitalism as we know it is greed, ruthless shareholder-driven expropriation of many large companies, verging on legalized looting with manifestations of it through executive or excessive executive and director remuneration, disproportionate percentage of profits, tax savings distributed as dividends, and astronomical amounts spent on share buybacks. I'm not going to give you my views on this fascinating image. Look what's happening there. There's a pickpocketer and somebody's attention is distracted in the crowd. Start to think about our corporations law. Who are the pickpocketers? Who's distracting the view from the real issues? And I really want you to think about this image and think how we can improve our corporate law, corporate governance models based on an all-inclusive stakeholder model. So my final 3 points are: keep on refining the all-inclusive stakeholder model on which the South African corporate governance model is based. Keep on focusing on ways to ensure companies are governed and managed in the best long-term interest, long-term and sustainable interest of the company as a separate legal entity. with the board and management considering and balancing the best interests of all stakeholders. And I have been shocked lately when I dealt with some younger academics from other disciplines, how they just accept what we have, how they just do not want to move on and criticize and challenge. So I want all of you to once again think about what Einstein said. The important thing is not to stop questioning. And I would hope that during this whole conference, you question, even if people do not agree with your view, question, keep on questioning, and that's how you will find and create a better corporate law and corporate governance model, not only for South Africa, but for the whole world. Thank you very much.
Thank you very much, Professor du Plessis. That was very interesting. I must say, my test for a good keynote speaker is that it's almost similar to an inaugural lecture, that it must be understood by those that are not steeped in the discipline. And as I'm not steeped in the discipline, I really think that you have passed the test, because you told us what the disruption is, and what future initiatives are needed. And I think that is very important. But from a South African perspective, I think it was rather reassuring to hear that we are groundbreaking and leading in a large part of these principles, and that our courts might have it a little bit easier than other courts. I also appreciated Fink. You know, I think I come from a private law background, so we also always look at the individual, and you know, we think of the workers and the other stakeholders, not just the shareholders. And I agree with you that they need change. We need to find these pickpockets, the greeds, those who are so greedy and looting, and that we've got to be vigilant and stay vigilant to ensure that we create a better, more sustainable situation around the world. So from my side, thank you very, very much. I really appreciate it. Found it fascinating and interesting. Much appreciated. And ladies and gentlemen, on that note, we have a comfort break now. Or Howard, would you like us to continue?
Thank you very much, Prof. We will continue right into the next session one.
I thought you might say so. Jean, if you're there, then I will hand over this chair to you. Ladies and gentlemen, enjoy the conference.
Thank you very much, Prof. Caneri, and thank you, John du Plessis, for your wonderful and excellent presentation as a keynote speaker. So we are going now to move to our second session, and we are going to have a presentation which is going to have a common heading by COVID-19 corporate law practice. Is going to be a panel discussion. We are going to have 3 speakers, and each speaker is going to have 50 minutes. So you are free to use your 15 minutes in any way you like. You will speak on 13 minutes uninterrupted, and I will inform you when you are still remaining with 2 minutes, so that you can wrap up. And for the participant, you can write your question in chat. We will have a discussion after all the presenters have already completed their presentation, and it's going to be almost 10 to 15 minutes. So the first speaker is Dr. Neil Killian from Northwest University. He's going to present a topic entitled "This Measure and its Relevance to Radius Clause in Insurance Contract." Over to you.
Thank you very much, John. Thank you very much for allowing me to present my presentation this morning. First of all, I would like to it's still a bit of a difficult situation. So if you don't mind, I would just like to give a presentation and have a question and answering session at the end of the presentation. I hope my suggestion is welcomed. Thank you very much, ladies and gentlemen. This morning we're going to focus on a first major or an act of God and its relevance to radius clauses in insurance contracts. This morning I'm going to focus on insurance contracts, insurance law. Generally I'm focusing on company law. Company law is always my first choice, but for this conference I thought by myself it will be a good idea if I can just focus a little bit on it and its relevance to an act of God, for example, COVID-19 or a notifiable disease relevant to the South African economy or the South African legal environment. So therefore, if we go to the next slide, the introduction. Very important in insurance contracts, an act of God liable to understand, since the very nature of insurance contract wordings is to cover an insured against any form of risk. Some insurers will generally specify liability only for a specific act of God event or to avoid liability for any act of God event. However, a unique clause is in existence, namely a radius clause. And a radius clause is considered to be a blended clause. It attempts to regulate an act of God, and it also tries to regulate, to reject liability for an act of God event. So in other words, it tries to accept liability within a specific radius, and it also tries to reject liability if the risk falls outside the radius clause. In South African law, there's a well-known principle in the law of contract, namely the freedom to contract, and the insurer is willing to accept in exchange for a monthly premium, and part of that risk, for example, an act of God. If the policy wording, there is a slim possibility that the contract may be terminated on the basis of the common law principle of supervening impossibility of performance. This is due to the legal nature of insurance contracts, which is to indemnify the insured for any losses or risk suffered. And there's also a possibility to accept liability for an act of God event and to transfer the liability or the risk to a reinsurer. And that is generally referred to as a reinsurance contract or a treaty. In other words, the insurer is liable, but his liability is shared by a reinsurer that in most cases accept liability for claims by the insurer. An example of a recent case here in South Africa is the Africa Hotels versus Santam, a division of which is hospitality and leisure insurance. And this case simply dealt with notifiable diseases, or commonly known as COVID-19, as an act of God event, and whether the insurer, Santam, could rely on a radius clause to limit its liability for a global outbreak of a notifiable disease. Santam generally accepts full liability if and when for example, COVID-19 occurred within a specific radius, and in this regard, the radius was 40 kilometers from the place of business of Africa Hotels, and the insurer is not liable because generally COVID-19 is a global outbreak, and therefore Santam simply argued that COVID-19 does not fall within a radius wording. The Africa Hotels case explains the legal difficulty of understanding the validity of a radius clause with reference to a global pandemic where the South African government tried to stop the spread of the disease by imposing relevant lockdown regulations. It is a unique clause, and it's also clear that the insurer, or Santam, acknowledges liability for notifiable diseases where a disease originated inside the stipulated radius. The legal difference between accepted and rejected liability is based on arbitrary radius distances. Some insurers here in South Africa included a radius clause of 40 kilometers, and other insurers included a radius clause of 50 kilometers. In other words, if the insurer is allowed to reject liability based on the policy wording. A division of an insurer, is it an unregulated concept? First of all, if we focus on citing of Santam, you'll see Santam, it simply says it's a which is hospitality and leisure insurance. If you focus on the uniform court rules here in South Africa, you will see, for example, that Rule 14 explicitly regulates how to cite partnerships, etc. But in this instance, there's a bit of a problem citing of Santam, because Santam is a legal person and is not a legal person in terms of the insurance law in South Africa. So for all practical purposes, to cite Santam as a division of which is hospitality and leisure doesn't make sense. And it's actually strange that the court or the judge did not focus on this of Santam in this court case. Hospitality and leisure insurance is simply referred to as a division, and a division is not a legal person. So in the Africa Hotels case, the difficulty lay in citing a respondent that had no legal personality to a matter, namely hospitality and leisure. Currently in the short-term insurance landscape, provision is made for the following business enterprises, for example, a non-mandated intermediary and a sole captive insurer. Underwriting manager and a non-mandated intermediary is generally binder holders on behalf of an insurance company. These enterprises are generally private companies or public companies, and as a result of a binder agreement between the private company or the underwriting manager and the insurer, the registered company must join, for example, the words underwriting manager to its name. While CIPC, or the Company Intellectual Property Commission, does not require the registration of the company's name to include underwriting manager, FSCA, the Financial Services Conduct Authority, specifically requires that these words be subjoined to the name of an enterprise that acts on behalf of an insurer as if it were an insurer, for example, an underwriting manager. To understand the differences between holders, reference must be made to the Insurance Act, which defines sole captive insurance as a binder holder shares in an insurer. These shares are generally ring-fenced. The profitability of the sole captive is solely based on the financial results of the sole captive enterprise and not on the financial results of the insurer. For example, in a case where the insurer is unprofitable, but the sole captive is profitable, therefore the sole captive may participate or share in the profits of the insurer. This is a very unique concept in South Africa. A few months ago, I was actually talking to somebody in Australia concerning our unique concept of sole captive insurance, and sort of an invention from the Lloyd's of London concept or module that's been incorporated in South Africa from a South African perspective as, say, for example, a sole captive insurance. In the Africa Hotels case, the court did not focus on an earlier explanation of binder holders or the purpose of a division. Accordingly, it's possible leisure insurance as an entity was previously an underwriter that merged with Santam. This is only an idea. It's an assumption. It's not to say it's really so, but I believe hospitality and leisure was, for example, an underwriting manager, and it simply merged with Santam in order to form a division that is part of Santam. In such cases, the original name of the merged company, Hospitality and Leisure Insurance, may be used by the insurer, probably because of the goodwill attached to it. Following the merger, the company, for example, the underwriting manager, as either a private or public company, will be deregistered and will continue in the future as a division of the insurer. The previous managing director manager will generally enter into a contract with the insurer whereby the individual profit-sharing arrangements. However, in the event that the division is unprofitable, it's also not a requirement to register the division's name, CIPC or FSCA, since a division has no legal personality. So therefore, if we focus on this citation, it should have been actually leisure insurance, hospitality and leisure insurance, a division of Santam, a division of hospitality and leisure insurance. Circumstances of the Africa Hotels case are also very interesting. The Africa Hotels case can be summarized as follows. Santam sold business interruption insurance in Africa Hotels, which operates or manages 7 different companies in South Africa. The insurance product is regarded as a short-term insurance product since Santam is a short-term insurer. The insured amount was for approximately R1 million for any losses suffered as a result of actions resulting from inter alia, for example, notifiable diseases. Subsequent to the global outbreak of COVID-19, Africa Hotels approached the High Court for a declaration order correct interpretation of the Santam policy wording that regulates interruption cover and whether COVID-19 is really a radius clause. Santam argued the importance of a radius clause because Santam simply said that no insurer would accept liability for a global pandemic. Santam's policy wording is therefore very clear that a notifiable disease or COVID-19 should have originated within a specific radius of the policyholder's place of business. And it's clear that COVID-19 simply did not fit this requirement. Santam argued further that the real reason why Africa Hotels interruptions was not really due to COVID-19, but was the result of hard lockdown regulations imposed by the South African government. As a result of these lockdown regulations, Africa Hotels cancellations for approximately 800 rooms here in South Africa, and they suffered financial loss of R5.1 million per day. Santam rejected most of these claims submitted by Africa Hotels because Santam argued that the losses were the result of the government-imposed lockdown. On the other hand, is that on the 1st of June 2020, nearly 4 months after hard lockdown regulations were imposed in South Africa, Santam unilaterally changed the policy wording simply to say
you have
that
2 minutes to complete.
Thank you very much, John. Amended its business interruption policies to avoid any claims based on notifiable diseases. This liability exclusion is subject to any radius clause. Thus, Santam tried to reject liability for all notifiable diseases in the future. If we focus on the next slide, it's very interesting to see the American approach to COVID-19. And in America, there were 2 separate bills. The first one was, say, for example, the pandemic risk bill, and the other one was simply the business interruption insurance bill. And it's very interesting to see the different criteria. In short, the pandemic risk bill simply introduced a form of reinsurance in America in order to accept liability between the federal government and the insurers. There's also a specific monetary value between $250 million up to $750 million, where the federal government will be solely responsible for COVID-19 claims in America and not the insurers. Only when the total claims exceed $750 million that the federal government and the insurers will share these risks per rata. And then the last slide deals with the conclusion. And with the conclusion, the Africa Hotels simply said that a radius clause, which is a blended clause, has 2 different interpretations. The inclusion of insurer liability within the radius and exclusion of liability outside of the radius. And the High Court simply said that this type of clauses are unreasonable and unfair. So in the future, I think no longer see radius clauses here in South Africa, and we will also no longer see radius clauses in any policy wordings in South Africa, at least relevant to business interruption claims. For this particular reason, business interruption claims will be honored in South Africa, irrespective of where notifiable will be liable for COVID-19 diseases. Thank you very much, John. Thank you.
Thank you, Dr. Kilian, for your excellent presentation. Let's move on to our next speaker, who is Professor Mongalo from Wits University, and is going to give us a topic entitled Helping Business to Mobilize Funding through Public Offering Security in Bond Listed and unlisted setting, a case for business transaction clinics in South Africa. Over to you, Professor Mongalo.
Thank you very much. Can everyone hear me?
Yes, we can hear you.
Okay, yeah, thank you very much. I have to acknowledge or to concede that I am pretty much moving away from a theme of COVID-19 because I am looking at business transaction law from the social justice perspective. And what I would like to first, pose is that in the area of work that I am involved, which is transactions law, particularly in the area of company law, it is very much unusual to hear anyone speak of social justice and associating it with transactions law. And I think that is where many of us as transaction lawyers are found to be, out of touch with what is happening within the community, mainly because we do not find a role for social justice, for best transactions law to play within the social justice circles. But this presentation is now concentrating on the introduction of business transaction clinics in South Africa, which will follow in the same model that the normal university-based clinics that deal with generic law have been introduced in this country over 40 years ago. Okay, we can move to the next slide. Yeah, well, this one, you can just skip it. It's just an introduction of who I am and where I'm based. Now, business transactions clinics are a form of an experiential forum. And as a result, you would find that they are actually undertaken in a setting like the one you see here. And I must acknowledge that this happened obviously before COVID-19, and that's why you see, even the way in which the participants are seated, it is not in any way respecting any of the this social distancing. But the message that I am trying to bring across here is that it is not just a matter of a classroom setting where you are actually transmitting information, but it's a matter of learning by doing. That is basically what Business Transaction Clinic is about. Can we go to the next slide? And this is how my presentation is going to be arranged. I will speak of the business transaction clinics in context, and I will then move on to business transaction clinics that are designed to address the community-specific issues that are relevant to the community in which the business transaction clinic is established. And I will speak about the business funding and revitalizing of the manufacturing industry in South Africa using business transactions clinic, and how setting up of the BTCs in South Africa will put Companies Act into the test. And I will ultimately conclude with important preliminary observations. And then I will talk about the research question, the proposed methodology and research design, because this is all part of a paper that I am finalizing for the publication with Speculum Juris. Okay, let's go on. Yeah, what is very interesting is that, as I have already said in my introduction, business transactions clinic will not be new in South Africa. Will not be new because they will be introduced in South Africa, but it is a phenomenon that has been for a long time happening in the US, where they serve as a fora for experiential learning. And what I have done in my research is that I have looked particularly at 27 law schools in the US and found that all of them had a business transactions clinic. And I have done a cross-section of those law schools that have business transactions clinics. And I have actually just summarized the 10 that I think many of you will actually know, which I think quite interesting. And I would like you to just have a look at the kind of titles that are given to the clinical law in relation to transactions law. In New York Law School, they are called Business Transactions Clinic. At Stanford Law, it's Organizations and Transactions Clinic. And at Harvard, it's Transactions Law Clinics. And at USC Gold, it's called Small Business Clinic. And at SMU's Dedman School of Law is Small Business Clinic and Trademark Clinic. And you see the variety there in terms of what it appears to be the emphasis of what the clinic does. And we can go further. Now, in this slide, I would like to show that the Business Transactions Clinic are usually designed to address community-specific business concerns. And this is in order to give services to communities in respect of transactional or business law, in respect of matters for which the community may not have the resources for them to pay at established law firms, because the services are quite expensive. And you will agree with me that if you would like, for an example, to set up a public company with a view to issuing securities in the public, and you want to go to an established law firm, you are going to have to pay quite extensively. But if the business transaction clinic were to be established, and therefore it was offering the service to the community, it will do it for a minimal fee or for no fee at all, except for disbursements and other filing fees. Now, in this regard, you will see that, for an example, at New York University Law School, the main emphasis there is on complex corporate and securities transactions. And it is understandable that the New York University Law School is covering the 5 boroughs of New York City, and they are basically specializing in areas that are affecting the area of New York. And most of the people who come at Business Transaction Clinic there are coming for complex corporate and securities transactions to be assisted with. Now, at Stanford, their main emphasis is on non-profit organizations and social enterprises, because this has been seen to be a main issue within the part of the California community in which they are situated. And at Columbia, which is pretty much in the same area as New York University, they are basically concentrating in the community in which community development transactions are seen to be important to be addressed. At Cardozo, for an example, the tech startups and securities arbitration is a #1 concern that they have identified, and they are providing services for that. At Detroit, University of Detroit Law School, their business transactions clinic is emphasizing trademarks and entrepreneur development. At Boston College School of Law, it's community enterprises. And at Penn State Law, it's intellectual property protection and entrepreneur assistance. And at Yale Law School, it's entrepreneurship and innovation generally. And at North Kentucky University's Chase College of Law is small business and nonprofit law. And at Hofstra, which is also in the New York area, is economic development. You can see a wide range of business concerns that Business Transactions Clinic are concerned with in the jurisdiction, in the areas that I have looked at and have surveyed. Now we can go further. Now, in the South African context, I think my research has actually established that there are 10 top challenges that are facing businesses, which I think business transactions clinics have to take into account this particular aspect. For an example, starting a business, mainly because of startup capital, or mainly concentrating on startup capital is the #1 concern of business. And the second one is dealing with construction permits. You can have a business transaction clinic in that regard. Getting electricity, the process of getting electricity, which obviously we know it is also posing challenges of the fact that the process is difficult, but still at the same time you may not even end up getting electricity because of this load shedding and stuff. And the fourth one is registering a property and getting credit and protecting investors. These are all mentioned as some of the main areas in which, if South Africa were to improve, it will actually take South Africa to in the top tier of ease of doing business, and in line with the ease of doing business surveys that are undertaken by the World Bank on a yearly basis. And it is interesting to note that even trading across borders has been identified as one of the top 10 problems that are facing businesses in South Africa that can actually be addressed, I think, through a business transaction clinic, and issues of insolvency as well. And I think the areas are quite varied. But from all of this, what I have identified is that business funding and revitalizing manufacturing in South Africa is basically the #1 issue that I think needs to be addressed in the South African context. We can go on. In this regard, what I would like to quote is the research that has been undertaken by the Ministry of Finance recently in 2021 regarding the manufacturing industry and industrialization of the economy as the main basis for our economy struggling, and which can actually put us back on a footing of growth that is actually expected in order to accommodate this inclusive economy that we are striving for. And in this regard, it has been identified that manufacturing industry has shrunk from at least 22% of the country's GDP in 2008 to about 12%, and translated in monetary terms, that is about 667.7 billion in 2008 to the current 545.9 billion in real terms. And at any rate, when you take the net present value of that particular figure, you will find that actually the difference is quite huge, and therefore there is a gap in the South African economy that needs to be filled by companies that are particularly in the manufacturing field, that should actually fill up that gap in order for us to get to where we were in 2008 and beyond, because the population is growing, the needs of the country are growing, and the needs of our region are growing, and therefore South Africa needs to play a crucial role in that regard. And I think from this perspective, the real chance of success lies in manufacturing and industrialization, insofar as growing the inclusive economy is concerned. And therefore, business in manufacturing and industrialization require in-depth research and extensive investment. And therefore, capital investment here is quite huge. And the chances of success in this particular area are quite great. And that's why I think business transactions clinics in this country should concentrate on helping entrepreneurs to get into this. I think one party in this country is actually running for municipal elections on the ticket of revitalizing the industries that are abundant in South Africa. And I think that they have got the thing on the ball. They have got their goals on the ball.
You have 2 minutes remaining.
Yes, okay, yeah, I will just wrap up. Now, what I would like to just point out is that Business Transactions Clinic in this regard can assist in identifying viable opportunities in manufacturing and industrialization, and assist in formalization of the registration and businesses, particularly in public companies, and therefore assisting in the drafting of the valuable MOIs and in the prospectus that needs to be filed with the CIPC. Can we go further? And in this regard, I think Chapter 4 of the Companies Act has really been underutilized ever since the Companies Act has been implemented. And I think Business Transactions Clinic need to concentrate on helping businesses so they could be able to access public funding, particularly through unlisted securities, by helping entrepreneurs to be able to draft their prospectuses and to be able to constitute, to register, formalize as public companies, so that they can be able to then access funding in an alternative funding way, rather than the usual way of applying for funding from the banks, which is usually requiring collateral which many businesses don't get. Therefore, using unlisted securities can actually be a huge benefit, or a huge boost to the economic growth and the revitalization of the economy in this regard. And my proposal is that universities in this country, particularly law schools, can play a crucial role in establishing business transactions clinics for the purposes of accessing alternative funding through unlisted securities in South Africa. Thank you very much.
Thank you very much, Prof. Mongalo, for your excellent presentation. Let's move on to our next speaker, who is Professor B. Topham. He's from Financial Sector Conduct Authority. The title of the presentation is the FCCA's current regulatory approach under the Financial Market Act, with specific reference to application of Section 81 of the Visory Order and the suspension of that. Over to you, Prof.
Good morning, everybody. We've got 12 minutes to just touch on some of the developments in the Financial Markets Act. One of the areas also touches on the Companies Act, which some of you might find interesting. So I'm just going to pretty much give a high-level thing, what you need to look forward to in the coming year. Also, I think most of you are aware of the most expensive SMS that was sent a few years ago by Marcus Jooste, and the Financial Sector Conduct Authority levied a fine in terms of the Financial Markets Act and used the formula which was set out in the Act to determine what the right penalty should be. And there was he's potentially on the hook for around about 600 million rand, and that one has now been appealed to the Financial Services Tribunal. It's going to the tribunal next month, and more than likely, I'm sure that because of the money involved, he will take that all the way through to the highest court that will hear it. So that's something that I think you may be interested to watch and determine how expensive just an SMS can be in terms of the Financial Markets Act, which talks about the publication of inside information, and whether certain of the evidence regarding proving that that SMS was specifically sent to people, it can become quite a technical argument in the future, and will be of interest, I believe, to the sector. The second application of the Act, which is a first of the application, would be regarding the suspension of the stock exchange known as ZARX. It was suspended on the basis of failing to comply with Regulation Act of the Financial Markets Act, which speaks about the capital adequacy, effectively requirements for a market infrastructure. And effectively, what's in question here is whether it's a good enough basis on which to suspend a stock exchange, or whether the regulator should be able to carry on giving extensions for market infrastructure to find investors to make sure that it has sufficient capital to offset the risk. The Act speaks about in the Regulation 8, subsection 2AB, if in the opinion of the authority, such liquid financial resources are insufficient to cover the risk involved, the authority may require the market infrastructure in question to obtain additional assets. And that's what's being taken on appeal to the Financial Services Tribunal as well. So that would also become quite interesting how the court interprets the section of the FMA dealing with the capital adequacy of various market infrastructures. Obviously, because we now have more than one stock exchange in the country, and there are other capital infrastructures that are also central depositories and things like that, its interpretation is quite important. Then a very recent case, five judges in the appeal court found against the FSCA in the question of the liquidation of a company called JP Markets. JP Markets was the application was done to place them in liquidation because they did not have a license to provide ODP, over-the-counter derivative provider, services to their clients. Traditionally, the FSCA will work in terms of the Financial Advisory and Intermediary Services Act, which says that they can act in accordance with what is in the best interest of financial customers, even if the company is not insolvent. Because the ODP regulations are contained in the Financial Markets Act, there's basically a cross-reference back to the Companies Act, and the court looked into what is just and equitable. And there, what is just and equitable, the company may not necessarily be fair to financial customers. And in the end, the court in this case basically said, the five judges said, Well, because the company basically almost on the steps of the court application for liquidation, put in an application for a license, that it would have been just and equitable for the FSCA to rather have pended their liquidation application and first considered whether their application was successful or not. Bear in mind that the company themselves had placed themselves into business rescue, which was another basis on which an application for a license would have been automatically not possible. So the FSCA are not very happy with the outcome, but we're now just going to make sure we amend the Act in due course to make sure that just and equitable can also have some reference to what's in the interest of financial customers and the customers of a financial institution. The final case we just want to highlight to the people in the 12 minutes is the Viceroy report that was issued against Capitec, the bank. It was quite in the press for a while. It caused a run on the shares of Capitec, and there were a lot of international short sellers on the share, and they made quite a bit of money, these companies, on the basis of Viceroy's report, which basically said that Capitec's financials were basically misstated, etc., etc. And what's important in this case is the application of Section 81 of the Financial Markets Act, which has been used before, was used against Steinhoff, for instance, been used against Tonga Hewlett itself for publication of false and misleading information. So Viceroy is almost like a journalist, but they're not, they're analysts, and this is where the interest comes in, is can we now start to say to a journalist who publishes something in a newspaper that causes the share price of a entity listed in South Africa to go up or down, can we hold them liable in terms of the Financial Markets Act? And that's the concern. And the most important part of this is that ought reasonably to have known. So what do these analysts have to do, in order to protect themselves against this? And in the case of Capitec, for instance, they issued the report, Viceroy issued the report, and then Capitec answered many of the allegations in SENS announcements, etc. And it appears there was no interaction between Viceroy and Capitec. There was no questioning or testing of their formulas and their calculations. And as a result, in our opinion, we said they ought reasonably have known that some of the statements they were making were incorrect. And on the basis of that, we issued them with a 50 million rand fine. They have a few more days left before their appeal to the Financial Services Tribunal is due. And thereafter, they'd obviously have to apply for condonation to be heard. But they've told a lot of reporters, and they've been quite active in the social media field, that they intend to appeal the decision. And we look forward to that interpretation. And I think what's going to be of interest to the academics is how the courts applied this section of the Act to people that aren't necessarily insiders. We all expect Section 81 to be applied against the company or against the directors. And obviously many people are waiting to see what happens against the directors in Steinhoff and Tonga Hewlett, amongst others. But this is the first, in that people that aren't directly involved in the company, just complete outsiders, are publishing information which is false and which had a material effect on the share price. And I think that's going to be of interest to people. And how am I 12 minutes? I think I should be almost done. So I have nothing else. And if we're under the 12 minutes, people can ask questions in the question and answer section.
Okay, thank you very much, Prof, for your excellent presentation. Now we are going to go to the Q&A question. I have checked the chat. There are no questions asked in the chat, but I have at least one question for each presenter, and then the audience will also be able to either type question in the chat box or be able to pose their question, but we have a limited time. So the first question, which is for Dr. Kilian, is with regard to most of insurance company, they normally exclude the vice-mayor or something which is act of God. And why do they like to exclude those events? And to Prof. Mongalo, you have done a research in the United States about the business transaction clinics. Do you think it's something which can be introduced in South Africa to improve the business transaction? And if so, how can it be done? And to our last speaker, who is Prof. Topam, with regard to the business rescue. So most of the company, before they get liquidated, they have to go to the business rescue. In your experience or in practice, how successful are business rescue in practice? Thank you. Does anyone from the audience have questions so that we can do one round? I don't see any questions, so you can proceed and answer the question, and then you can move on. Over to you.
Much, John. Thank you very much. Why to exclude an act of God event? If we focus on the Santam case and also on the God risk case, it's very interesting that they focus on a radius clause to exclude liability. If they did not focus on a radius clause, then the next step is simply supervening impossibility of performance to terminate a policy. And the insurers, Santam and God Risk, very carefully did not argue supervening impossibility of performance, because that would terminate all their policyholders who had, say, for example, business interruption policies. So very clever from the insurance companies not to argue supervening impossibility of performance to terminate the policies. They would rather try and exclude an act of God, specifically in a policy wording, or in this regard, by means of a radius clause. But once again, it's very difficult to understand an act of God in terms of insurance law, because insurance law deals with to insure any form of risk. So therefore, a global pandemic can also be seen as any form of risk that is insurable, or you can exclude it explicitly in the policy wording. So it's very difficult to understand how to exclude or how to include risks from an insurance law perspective. Thank you very much.
Over to you, Prof. Mongalo.
Thank you very much. The question is it recommended that business transactions clinics be introduced in South Africa? And if so, how can that be done? Now, my research has shown that it is in fact about time that business transactions clinics be introduced in this country. And the experience of the US, if there's anything to go by, is that the American Bar Association, which I could say is the equivalent of the Legal Practice Council, actually recognizes the clinics, and they are basically registered with the American Bar Association in most cases. And I found that in some jurisdictions, the business transactions clinics are also registered with state departments that are responsible for registering businesses. And for an example, in our case, it will be the Companies Intellectual Property Commission. And the Companies and Intellectual Property Commission at the moment doesn't have the authority to recognize the clinics in the context of what I've discussed, but it's something that can actually be considered from that perspective, because I think it can actually go a long way towards assisting our communities in areas that are not currently covered by the existing clinics in the country. Thank you.
Okay, thank you very much. The next speaker.
Yeah, about business rescue. Currently, I don't have much involvement in that as a regulator, but in my former life as an auditor and an attorney, I have dealt with it. I was quite involved with the one-time airline business rescue, and that obviously was not successful. And in most cases, I must admit, I haven't seen success being applied. There are isolated cases, and sometimes those cases may not have even needed business rescue to have been able to be successful. But they were on the cusp of being of needing the protection. So I think in those cases, if in doubt, maybe it's not a bad idea to get the protection. It'd be interesting to see what comes out of ComAir's business rescue now. They were listed, and they obviously operate the British Airways franchise. and whether they are going to be successful with their application. I'm hoping for the country's sake that it is the case. But I think in general, the cost of business administration and the fact that people, the negative reputation that sometimes goes with it, people aren't prepared to extend the credit to such entities, and that normally is the basis for its failure. So unless you've got a source of credit, it's very difficult for an entity to trade out of business rescue.
Thank you very much. There are some few questions from chat, and I'm going to read them, and then whoever it is addressed, you can immediately take time to answer them. The first one, I think, is from Hank, is addressed to Dr. Kilian. Do you know if any insurer have changed their contract wording already? And the second one is from Tumelo, is to Dr. Kilian again. So what is the purpose of an insurance if you have to exclude acts of God? And the last one is from Hank again. The insurer also tried to argue that there was no causal connection between the events and the damage without success. So I think most of the questions were asked to Dr. Kilian. Over to you.
Thank you very much, John. Yes, the Sansom case and the Godress case did focus on the but-for case, but it was more an obiter dictum statement because they've answered it already in the radius stipulations in the policy wording. But nevertheless, with the but-for, the court simply said it's one single event. So there's no distinction between lockdown regulations and COVID-19 as a disease. So in terms of the but-for test as applied by the appeal court,
okay, I think.
The second question is to exclude an act of God. Exclude an act of God, it's based on the principle of freedom of contract. So most insurers can either include or exclude an act of God event. It all deals with the risk, and sometimes insurers always have a reinsurance treaty with a reinsurer, and the reinsurer will also simply specify the type of risks they are willing to accept on behalf of an insurance company. So a radius clause was introduced into the South African insurance law landscape approximately 15 years ago because of developments in America as well as in Europe. So a radius clause is actually a very unique old clause in South Africa. And as we've seen with the Sansom and the Godress case, it's no longer relevant from a South African perspective. And the last one is any policy wordings that have been changed. Yes, Sansom already changed their policy wordings concerning business interruptions. They've actually changed the policy wording while they've accepted claims from Africa, and they've changed it last year, 1 June 2020. So that was also unfortunate circumstance to change the policy wordings to exclude liability. You notice that there's a problem with radius clauses in relation to a global pandemic. Thank you very much.
Yeah, thank you very much, Dr. Kilian, and thank you very much for all the presenters for your excellent and wonderful presentation. You have really shared knowledge, and you have contributed to the existing knowledge. I'm now going to hand over to our next chair, who is Mongalo. Over to you.
Thank you very much, Dr. Kanamjire. Good morning, colleagues. I will be chairing this session 2 on COVID-19, company law, corporate governance, and practice. We have presenters who's going to be Dr. Stuop, Dr. Sola, Dr. Ngwenyama, and Ms. Motlogela. Without wasting any time, Dr. Helena, it's over to you. Dr. Stuop, it's over to you. All right, I see Dr. Stuop seems not to be currently with us. In that regard, Dr. Sola, can I please catapult you and ask that you present, and then we'll give over to Dr. Stu at a later stage. Dr. Sola.
Good morning. Are you hearing me?
Yes, yes.
Good morning.
We can hear you, Dr. Sola.
Okay. Okay, thank you very much. It's nice to be here. Please share, can you please share my PowerPoint? Hello?
Yes, I will just beam up your presentation now, Dr. Sola.
Okay, okay. Oh, so good morning, colleagues. The topic of my presentation is COVID-19 rewriting the rules of corporate governance in Nigeria. And the next slide, please, which is just the structure of the presentation. Is on the introduction, the definition of the key terms, theories of corporate governance, where we are going to discuss some corporate governance crisis in Nigeria. Then we go to the development of corporate governance codes in Nigeria, and some provisions that might mark corporate governance under the new Company and Allied Matters Act of 2020. Then we now answer the question, is COVID-19 rewriting the rule of corporate governance in Nigeria, before we go to the concluding remarks. So we are now on introduction, which is on the next slide. Basically, we find that COVID-19 crisis is unique, and it is an unprecedented epidemic. It started as a public health emergency, and it has transformed into a financial and economic crisis of an epic proportion. The crisis was notable for the speed of change, the breadth, and the shape of its impact. And it has impacted and still impacts the economy and the society in diverse ways. Thus, the impact of this crisis, of this COVID-19 crisis, is devastating in a way that all businesses must make far-reaching adjustments. They must grapple with new risk and unexpected imperatives in order to survive. And Nigeria is essentially, is highly vulnerable to this crisis for many reasons, because it really depends on oil, and oil was, there was nobody to buy oil during that period. And the economy is failing, and many businesses are failing. And you know the effect of this. It leads to high unemployment, great hunger in the land. There is crime, increase in crime and antisocial behavior. And you can imagine the inflationary times, which we now have. So let's now go to the definition of the key terms. What is corporate governance? What corporate governance basically is a system of rules by which firms are controlled and directed, which involve the balancing of the interest of the corporation's various stakeholders. We may say that it involves legal and non-legal rules used in encouraging the active participation of stakeholders and shareholders in corporate decision making. And corporate governance encourages corporate social responsibility, which is the communal responsibility of corporations towards the society and the host community. Then they bring us to corporate law. And what is corporate law? Basically, corporate law is the body of rule governing the operation, the activity, the structure, formulation, and the solution of a corporation. It guides a company from its birth at formation till its dissolution when it's liquidated. And the main act in Nigeria for this is what we call Company and Allied Matters Act 2020. It deals with business registration, limited partnership, general partnership, limited liability partnership, incorporated trustees, different types of companies like companies limited by shares, unlimited company, and companies limited by guarantee. They are all guided by CAMA, that's Company and Allied Matters Act. The next slide, please. So, what are these theories of corporate governance? The theories of corporate governance. One is the agency theory, which basically states that the directors and managers are the agents of the owners, who are the shareholders, and they must act in their best interest. This theory is only interested in the interest of the shareholders alone. And it seems that Nigerian company key into this particular theory more than any other one. There's a time during the pandemic when, for instance, one bank known as Access Bank, it gave a donation of 1 billion naira to the federal government of Nigeria, donated ambulances and a lot of things, and which was a huge sum. Then afterwards, in the next maybe 3 weeks, it proposed to lay off 75% of its staff. So you could see that what it did may not even be altruistic. Maybe they do it did it because they know that it is tax deductible. So at the end of the day, there was a huge outcry, which made them to tamper, the company to tamper down the issue, but eventually they did retrench after the COVID, the pandemic is over for some time. Then the second one is stakeholders theory, which basically states that the managers and the management and the directors are accountable to a broad range of stakeholders, including shareholders, suppliers, host community, and employees. And this governance structure here advocate diversity. It even states that different persons should hold the offices of chairman and CEO, chief executive officer. Then let's go to the third one, which is the stewardship theory, the stewardship. This one proposes that stewards are the husband, the interest, and maximizes shareholders' wealth. And it proposes the fusion of the office of the director, the chairman, and the CEO in order to reduce agency cost and power struggle. The next one is resource dependency, which provides that directors provide access to resources needed by the firm and their linkages to the external environment. You talk about insider, business expert, support specialist, and community influencer. There are other ones, other minor ones, like transaction cost theory, like sociological theory, like class hegemony theory, but that one will waste my time. Don't let me go there. We have really dealt with a major theory. So I would like at this junction to discuss what I call some corporate governance crisis in Nigeria. There were bank failures at different times. In the 1980s, there were bank failure. There was bank failure in 2009, which was devastating. And you know what bank failure is? It affects the ordinary person because the depositors who are ordinary citizens, their money has gone down the drain, which made for mergers and acquisition, removal of licenses, withdrawal. It leads to a lot of people going into jail. It even made the government to reconsider that there should be privatization and commercialization of public enterprises. There was even what we call the failed bank tribunal that was done at that particular period. So this issue make the emergence of corporate governance to make it very, very important. and that leads to the law of corporate governance codes that we have in Nigeria. Next slide, please. So there were now proliferation of corporate governance codes. We have the Financial Reporting Council of Nigeria. The government created a Reporting Council of Nigeria by an act of legislation to start drafting corporate governance code. And some companies have even taken them to court that they have no right to prescribe for them, and they won in the court, in the hotels and the Federal Reporting Council of Nigeria. Then there are others like Security and Exchange Commission. They came up with their own code. The telecom industry came up with their own codes. The Bank and Discount House, there is a code that was issued by Central Bank of Nigeria. That is mandatory. It's mandatory because the Central Bank insisted that the banks should do certain things. Then the Code of Corporate Governance for Insurance Company, that is the National Insurance Company Commission. Then Code of Corporate Governance by licensed pension fund operator. But the problem with this code is that some of them make different provisions. So sometimes there are companies that are at intersection of that are regulated by more than one agency. So they don't know which code to adhere to when there is conflict. Then, next slide, please. There are certain corporate governance provisions in newcomer, that's in the New Company and Allied Matters Act 2020. The old Company and Allied Matters Act that we had was in 1990. You understand? So this one was just promulgated last year. The old act had a lot of deficiency. So you find out that under Section 2240 sub 2, it allowed private companies now to conduct their AGM electronically. Newcomer also provide that the offices of CEO, Chief Executive Officer, and Chairman of a public company should no longer be held by same person. And Section 275 of CAMA mandate all public companies to have at least 3 independent directors. Then another section of CAMA provides that suitable person for appointment as director of public company must disclose his directorship of other companies, and they must not hold directorship in more than 5 other public companies. And it also provides that that you cannot hold a directorship in more than 5 companies. Those are some of the provisions of the newcomer, which works towards incorporating other things that is in corporate governance. Then, our question, we now have to answer our question. Is COVID-19 rewriting the rules of corporate governance in Nigeria? Yes, I think it is. Though the CAMA was made before, without thinking of corporate before COVID came into being. But we now know that COVID has affected the way we relate. It has affected the way everybody operates. It has even affected business. In fact, in the Federal Republic of Nigeria, a fraction of people are even going to work, even up till now. The government says a certain percentage of people, some people will go on Monday, another one on Tuesday, on Wednesday, so that there won't be a lot of people lumped up together at the office. So everything is now going on. Yes, sir?
You have less than 2 minutes remaining.
Okay. So it seems to have changed the way business is being done, and there are heightened expectations for societal engagement from corporation in Nigeria. Then this now brings me to the concluding remarks. COVID-19 seems to have a far-reaching effect on the Nigerian economy, on the corporation, and even on corporate governance, that companies are even adhering to it for their own interest. And it seems that the Nigerian companies are shifting from the agency theory to more involvement of the stakeholders, moving towards stakeholders theory. Then COVID-19 itself may be demanding a review of certain provisions of CAMA in order to foster good corporate governance in Nigeria. I thank you all for listening. Thank you.
Thank you very much, Dr. Sola. Whilst Dr. Helena is still sorting out her connection, we will go ahead and have Dr. Ngwenyama presenting for us. Lerato, over to you. Dr. Ngwenyama. All right. I think Dr. Ngwenyama is not with us currently. We will go ahead and have Ms. Motlogelwa presenting, and then we'll come back to Dr. Ngwenyama and Dr. Stewart. We are going ahead with Ms. Motlogelwa.
Am I audible to everyone? Thank you very much. Good morning, colleagues. My presentation is based on the legal analysis of the impact of COVID-19 on shareholder activism and corporate governance challenges in South Africa. The structure of my presentation will be as follows. I will begin with introductory remarks, followed by the definition of key terms, the impact of COVID-19 on shareholder activism in South Africa, and then consequently discuss the adequacy of the measures adopted to mitigate the impact of COVID-19 on shareholder activism, after which I will present the concluding remarks. Basically, this paper seeks to discuss the impact of the COVID-19 pandemic on shareholder activism endeavors by shareholders in public companies in South Africa. I will discuss how the use of technology could be adopted to enhance shareholder activism in South Africa during the COVID-19 pandemic. Furthermore, I will discuss the adequacy of the measures adopted by the JSE to enable shareholder participation in investee companies during this pandemic. Accordingly, I will discuss factors such as a poor legislative framework, shareholder salience, various restrictions imposed by the COVID-19 pandemic, and the alterable provision of electronic meetings under the Companies Act. I start off with the definition of key terms. Shareholder activism basically relates to the actions undertaken by shareholders to influence the management of companies regarding a range of issues relating to the corporate performance of their companies. Corporate governance, although the term could be defined in various ways, I found that the manner in which corporations are regulated and managed best encapsulates the idea of this presentation. Shareholder engagements refer to the use of different strategies by shareholders to communicate with and influence the company management of investee companies. Next slide, please, Mr. Mongalo. First of all, I will discuss the lack of an adequate framework for shareholder engagement. Now, the Companies Act regulates shareholder activism for both retail and institutional shareholders in South Africa through various sections that relate to shareholder rights. The Companies Act, however, does not specifically provide for the promotion of shareholder activism through an engagement framework that seeks to facilitate shareholder engagement between company management and shareholders outside of the annual general meeting and general meetings in South Africa. The AGM is important, very important to note, that the AGM is an important corporate governance tool, as it allows shareholders to participate in their companies through various actions such as voting, proposing shareholder resolutions, and keeping abreast of developments in the company. The lack of provision of informal engagement processes between companies and shareholders could have increased shareholder passivity in South African public companies during the COVID-19 pandemic. In this regard, shareholder passivity relates to the inadequate or lack of shareholder engagement with their companies. Now, the challenges that are specifically associated with the COVID-19 pandemic relates to travel restrictions and social distancing measures that were imposed due to the pandemic. All of these have led to most companies in the Johannesburg Stock Exchange having to postpone their annual general meetings. The lack of technological advancement in facilitating shareholder meetings has led to very poor shareholder engagement in South Africa during this pandemic. This has resulted in a negative impact on shareholder activism, as the AGM is the sole platform for individual or retail shareholders with insignificant holdings and some institutional shareholders also with insignificant holdings to engage with their company management. The COVID-19 pandemic has also led to the exacerbation of shareholders' inferior access to company management. This condition can otherwise be referred to as shareholder salience. In this regard, shareholder salience refers to the degree to which company managers give priority to the claims of their shareholders. More broadly, I would say that shareholder salience refers to the degree to which various stakeholders in the company are visible, vocal, and important to their companies. The lack of the previously mentioned engagement framework, coupled with the postponement of in-person AGMs, has led to non-salient shareholders having little to no access to company management in order to actively participate in their companies. Ultimately, these shareholders are left without a platform to participate in the governance of their companies or to engage with company management. Next slide, please. At this stage, I will highlight the lack of technological development in public companies. Now, the Companies Act provides for electronic meetings, and most of the companies on the JSE have opted for in-person AGMs, which has been a challenge during the pandemic. This problem is not specific or unique to South African companies. It's a global problem in most companies. The lack of technological advancement in South African public companies has failed to promote shareholder activism through mitigating the costs involved in pursuing shareholder activism and enhancing shareholder engagement. This pandemic has further highlighted that public companies have failed to put in measures or contingencies in place to mitigate the impact of extraordinary circumstances, such as the pandemic, on public companies. In this regard, I will discuss the measures adopted to mitigate the impact of COVID-19 on shareholder activism. These measures include the partnership between the JSE and the meeting specialist, which were introduced to facilitate virtual meeting services, as well as electronic accurate voting. The biggest obstacle to virtual meetings and electronic voting prior to the pandemic included fears over moderation of shareholder questions through cherry-picking favorable questions, ignoring unfavorable questions, or completely rephrasing them. Additional obstacles to virtual meetings included the fear of shareholders in regard to the limitation of their ability to adequately engage and express their concerns or raise questions directed to the board of directors. The meeting specialist platform, in my view, is adequate to facilitate shareholder activism in public companies, provided that there is minimal director interference. And director interference can take place through moderation and any other interference meant to minimize shareholder voice. It would also be necessary to fully comply with the electronic meeting provisions of the Companies Act. The measures introduced by the JSE are adequate as they enable real-time shareholder participation in companies from any location and through the use of a range of technological devices. The Meeting Specialist platform enables continued shareholder participation in the governance of public companies during the pandemic and going forward. My concluding remarks for this presentation include that the COVID-19 pandemic has undoubtedly impeded the facilitation and promotion of shareholder activism in South Africa. Companies should have measures and contingencies in place in future to facilitate shareholder engagement and participation in corporate affairs under extraordinary circumstances. Furthermore, policymakers should consider adopting the use of technology more extensively under the Companies Act to promote shareholder engagement in public companies. Lastly, the Companies Act should specifically provide for the promotion of shareholder activism through the establishment of a framework on clear communication channels or strategies between shareholders and investee companies. Such an example of a framework could be seen in the jurisdiction of Australia, where the Australian authorities have in fact created a practical framework that enhances listed companies' relationships with their shareholders. The Australian Institute of Company Directors, for instance, set out the legal structure governing the relationship between boards, shareholders, and the executive. Thank you very much.
Thank you. Thank you very much, Ms. Mutlogela, for your presentation. We are now going to move to Dr. Ngwenyama. Dr. Ngwenyama, please take over and talk to us. Thank you. Dr. Ngwenyama, kindly unmute your microphone.
Can you hear me now?
I can hear you perfectly, colleague.
Wonderful. Thank you, dear colleague and chair. I just want to take this opportunity to thank the organizing committee for the invitation and the warm welcome to NW Mahikeng, though we are virtually there. So if I happen to be cut off, just know that we are within load shedding. So I might move. I try to move into the car now to secure a bit of connection and stuff. So I will switch on my camera, not wasting any time, and proceed with the presentation to know that you are not speaking to you are not hearing a robot. I'm actually here presenting. Thank you so much. I'll be presenting on another topic which says a staircase or a safety net, the significance of corporate social investment during the social unrest. It's a case study of Coca-Cola Company in KZN. Corporate social responsibility has been defined as business decision-making, which is linked to ethical values, compliance with legal requirements, and respect for people, communities, and the environment. This particular concept, it is a comprehensive set of management endorsed policies, practices, and programs that are integrated throughout business operations and decision-making processes. So corporate social investment, that is henceforth it will be CSI, is an external to the normal business activities of a company, and it's not primarily undertaken for purposes of increasing company profits, nor is it driven primarily as a marketing initiative, although it can help a company develop a competitive advantage. Rather, these projects aim to assist, benefit, and empower marginalized individuals and communities. CSI has a strong developmental approach and utilizes company resources to benefit the individual and community. CSI forms the significant part of the sector's contribution to South Africa. So in South Africa, or particularly in KZN, or the case study that I'm working on of Coca-Cola, their focus is enterprise development. That is the development of local businesses, including assistance with starting and sustaining businesses. So during this time of the unrest, but before the unrest, they have been assisting in the creation of a Black-owned security and carrier firm, and then assisting in the development of operational and financial capacity for small enterprises, particularly in the locations of KwaMashu, Umlazi, and so on and so forth, such as cafeterias, spaza shops, car wash facilities. So when the unrest came in, what I've discovered through the study that I've undertaken is that Coca-Cola in this particular business or in these particular townships, it has given these upcoming Black-owned businesses like fridge, and then it also supplies them at the first stock, it gave them the fridge with drinks inside, and then the next stock, they were the ones that were buying from Coca-Cola, and then they were given these fridges. Others, they were given containers. Others, they were given facilities to ensure that their businesses are sustainable and they move smoothly, and so on and so forth. But when the social unrest came, many of these businesses which were being supported by Coca-Cola, they were not actually affected, in that nothing was broken or nothing was stolen, because of when you ask questions why they did not, it's because they would respond and say, because Coca-Cola is helping our people, so we cannot destroy that. So in a way, when we ask whether is it a staircase or a safety net within the study, I think it became a safety net for Coca-Cola, because those fridges, they are there. They are not owned by the particular business also. They're owned actually by Coca-Cola, but Coca-Cola has placed them there so that it assists them in putting their stock, and also them gaining on the other hand. So those fridges and the containers, some of which were given, some of which were still, they were provided to just use for the time being. They were not vandalized, they were not destroyed. And the responses of the community or the people who were involved in the unrest and stuff, they say, we could not destroy this because Coca-Cola has been there since from ages, supporting those Black businesses which are coming up, are arising. So we could not touch it because we knew that it was bread for them. It could assist us as a community and also assist those who within the community. So within that, whether it's a staircase or a safety net, I think it's a safety net, particularly for Coca-Cola, because some of the properties were not vandalized in these townships. But when also you look at it, it could be a staircase for Coca-Cola, in that Coca-Cola in those areas which were not affected by the unrest, where their fridges were not vandalized, for instance, they were not. They did not suffer any damage to like replace the fridges and ensure that they bring new fridges or have them fixed. So they were able to just to continue when businesses opened without any problems of having to fix fridges or having to bring in new fridges. They were able to continue just bringing stock and continue with business as usual. So it was a staircase for them, in order they were able to move forward without being pushed back by the damages that were caused by the social unrest. So in a way, I think many businesses in South Africa, especially big companies, they should start to invest in CSI initiatives, because this also, not only does it benefit the community, but indirectly or directly, it does benefit the particular company when we have such things as social unrest. You know, particularly also when you looked at things and how it transpired in KZN, you could see the communities where the containers of Coca-Cola were there, the fridges of Coca-Cola were there. They were standing there and say no to this property, no to this property because it's sponsored by Coca-Cola. Coca-Cola is feeding our people. Coca-Cola has created job for our people. So I think it's an important thing that businesses should be involved in, because it can be a staircase on the other hand and also a safety net. But in this particular instance, I think it served more as a safety net for Coca-Cola company, because only just a few areas where people were ignorant of the fact that Coca-Cola was assisting the community, was changing and improving the community, whereby you find that their fridges or the containers provided by Coca-Cola for Chisanyamas and so on and so on, they were destroyed. By it. In majority of the communities, even the community members themselves, they were able to stand ground, to stand firm and say, do not vandalize this property, do not touch this property. It is sponsored by Coca-Cola. Coca-Cola has been assisting us for so long. So I think it is important that we have such initiative, and businesses should start to invest more in the community, because when you invest more in the community, you know, when you uplift the community in such a way that the community becomes independent and no longer dependent, and is able to survive on its own without having to need cash injections or some assistance or support even during these difficult times. Because we have seen after the social unrest, those businesses which were not touched were protected because of what Coca-Cola has been doing for them for years. They were able to move in and jump into production, or jump into doing business as normal, like nothing has happened, because of they did not suffer any damage in that regard. So I think enterprise development is very much important, and it will bring about growth, particularly to the youth. So the value of CSI activities, in conclusion, significantly exceeds their costs in the future cash flow generated. Employment is created, taxes are paid on profits, and the multiplier effect of employment are encountered for. So CSI activities, you know, they should be funded, you know, even if you assist or support, not in mind of receiving profit or receiving something in return, but you know, when you are able to have your brand established, your brand protected, you know, when you have your name on a particular thing, you're able to be saved because of what you are doing in the community, because of what you are doing in the community. So the intangible benefit that CSIs brings include the quality of lives, improvement of lives in communities, you know, health improvements, building the skills and knowledge gap in South Africa, contributing towards productivity in the country, and contributing towards the BBBE objectives. So I think it's very much important that most businesses should jump in to CSI initiatives, because they bring about a safety net for them and also for the particular community. Thank you so much. Thank you so much.
Thank you. Thank you very much, Dr. Ngwenyama. Thank you very much for a wonderful presentation. Dr. Stuop, are you here, Dr. Helena? Can you just give us an indication if you are here and if perhaps you can present? I don't think that she's here. All right. In that regard, I think we will go on to the question and answer session. I have noted some questions in the chat that have been directed to the presenters. The first one is to Ms. Mutlogelwa. It's from Mr. Torerai. What technology do you propose, and possibly why, in enhancing shareholder activism and corporate governance in South Africa?
Thank you for the question, Mr. Torerai. I would suggest various technological platforms or instruments, such as websites, Q&A sites, shareholder web forums, supporting webcast AGMs that in turn support hybrid AGMs, as well as the presentation of the virtual results of the votes, of the concerns of the shareholder, and other matters that are raised by shareholders. Thank you.
Thank you very much, Ms. Mutlogelwa. The next question comes from it's in fact a comment from Prof. Kloppers. He says, it is quite refreshing to see that CSI paid off in this regard. And it underlines the importance of both CSR and CSI. I see Prof. Mongalo also has a comment here. He says, shareholder activism is essentially limited by shareholder empathy, as shareholders do not regard themselves as the main actors in corporate governance. So, Ms. Motlogela, what are the best incentives the law can come up with to engender shareholder activism? What incentives can we have?
Thank you, Prof. Mongalo, for that question. I think as far as incentives are concerned, the policymakers with regard to the Companies Act could take a few steps. For example, in regards to the derivative action, shareholders find it difficult to use that remedy because there's no incentive, as the costs accrue to the company and not to the shareholder that are awarded from the action. In addition to that, shareholder activists have to bear the burdensome costs of such a remedy. So that's an example of one incentive that can be given in terms of the derivative action. Thank you.
Thank you very much, Ms. Motlogela. We have a comment from Chidibere, who says the absence of CSI and CSR encouraged the looting of many businesses during the social unrest that preceded the end of SARS protests in Nigeria. And we see Chiasa saying, refreshing presentation, Dr. Ngwenyama. I have a question for you, Dr. Ngwenyama, here. How can companies, I mean, we understand that most companies have been adversely affected by the COVID-19 pandemic. How can they ensure that they still manage to support the communities and carry out their CSR and CSI objectives? How can they do that, especially now during the COVID-19 pandemic? Dr. Ngwenyama, kindly unmute. Dr. Ngwenyama, are you there? All right. I think Dr. Ngwenyama has indicated that he has challenges with connection, so he might not have got that. But thank you very much, colleagues, for the wonderful and excellent presentations. Thank you also for all the questions that came through. They are quite insightful, those questions. Thank you very much, colleagues. I think Dr. Helena is not yet in. We understand, colleagues, we understand that we have challenges with regards to electricity and load shedding. So we will accommodate Dr. Helena later on during the day. For now, I am going to hand over the reins to we are moving on to session 4, and I'm going to hand over the reins to the next chairperson of the session, and that is going to be rather session 3, Dr. Hamaziripi. Dr. Hamaziripi, over to you.
Sorry, I'm falling in the middle of proceedings. I also apologize for just unmuting myself, but I do hope that I'm still maybe on time to join the session.
You are still on time. Please go ahead, Dr. Helena. Thank you very much for joining us. Go ahead and present.
I must sincerely apologize. I'm speaking to you now from my car next to the Okaapseweg because I just hightailed it to somewhere that had a cell phone tower working. I've never had this problem before during load shedding, so it is unprecedented for me. I must sincerely apologize. I'm not going to switch on my video. I am going to share my screen though, or try. It's not allowing me while the program is showing. Could that possibly be removed? Thank you very much. So then I'm just going to quickly share my screen. There we go. If you all bear with me, excuse me again, my profound apologies for this. Right, and then if I can just start, there we go, from the beginning. There we go. So with no further ado then, I am Helena Stoop. That pronunciation is indeed Stoop, from the University of Cape Town. And I'm going to be talking to you about King and the application of the statutory and common law duties of company directors. That was the slightly narrower focus of my thesis, but it really has a slightly broader application as well, in that, as Professor du Plessis earlier noted, King can really be used in interpreting and applying other provisions of the Act as well. So if I can then, sorry, just try to move to the next slide there. I'm going to by just quickly referring to this comment from Nine already. And it just really again resonated with me how it is still true. So a commercial instrument of formidable effectiveness, it's feared because of its power, hated because of the excesses with which that power is used, suspect because of the extent of its political manipulations within the political state, admired because of its capacity to get things done. From the turn of the 20th century to the present, its position as a major method of business organization has been assured. Although it was abused, no substitute form of organization was found. And the problem remains, I think, today. How do we make it a restrained, mature, and socially useful instrument? And I think that is particularly important in the context of a developing economy like ours. I think it is paramount in the light of what COVID has shown us, and this shock to the global business community and to people's livelihoods and so forth. And again, we're talking to one another with COP26 looming in the background. So we have great pressures, I think, to reform, and the clock is ticking for us to get our act together. So I'm covering a lot of ground because actually, if you start tinkering with this, you do find that it touches on almost every great debate in company law. It really touches on how we see companies and how we think they should best be regulated. So there's a lot of ground to cover, and I'm going to be touching on some things relatively superficially to allow time to get through everything. And I'm going to also, given the audience, take a few things for granted. So firstly, some familiarity with the Companies Act and the legal landscape. So of course, we've got the Companies Act, other relevant pieces of legislation that regulate and govern companies, and then of course, the King Code. And the King Code really was a trend setter, and still in many respects is. We now are at a point where we have an apply or explain regime, which is a slight nuance or a variation from comply or explain, which we had. And again, enforced really directly and clearly in the context of listed companies because of the JSE rules and the application of those. But in the context of unlisted and private companies, the question is a little more open-ended. And here, of course, we have a reference in King itself clearly to the fact that the courts might draw from King when interpreting and applying specifically the director's duties. And we have seen the courts do this. So I'm just naming one example. I'm aware of at least 6 or 7 cases where the courts have mentioned King. And this Minister of Water Affairs and Forestry, quite a famous one, the one where the entire board all at once resigned. And I think this is a particularly notable mention of King because it was in particular the environment that was in issue here, or that was mentioned here by the court. So that just by the way of background and context. And I must say also, I think as will become clear as I continue, there is quite a bit of nuance in this discussion of the application to unlisted and private companies. So the relevance of the director's duties, well, the directors and directors' duties have received a lot of attention simply because they steer the ship. Directors, of course, are the directing mind and will of the company, we famously know. And so it makes sense that one would look at the director's duties if you're looking at reforms in general, and that it has been given a lot of attention. And if you're going to be reading the code in, if I can just informally refer to it in that way, 2 duties in particular lean themselves to that. Care and skill, the duty of care and skill. And I think it is interesting here because that duty is a little bit of a lame duck. It's not very vigorously enforced. And a lot of the time it is because there aren't concrete measures. So I think there's some very interesting nuance that the codes can bring to that, and possibly reinvigorate that duty. Of course, noting that it stands within the broader framework of duties, of remedies, and this slow enforcement of this, and again, as I said, mentioning or touching on other debates, because this is to do with, I think, shareholder enforcement and so on. But then also the best interest of the company. And here it really pulls in that whole stakeholder debate that much has been said about this morning. And I would argue that actually the King is really a little bit ahead of the Act still in where it stands on the stakeholder debate. But of course, it's not only in the context of the duties. And I've recently come across, sorry, that's a slide that I thought was there that isn't. I've recently come across interesting reference to this in the application of section 163, which is of course that oppression remedy in the Companies Act, where applicant was basically basing that application on a lack of compliance with King. And this was in the context of a private company. And one wonders in what contexts and to what degree, and indeed how, the courts will then draw from this material. And that then brings us to what I call section. So this intersection between governance code and black letter law, for lack of a better word. There are, of course, a lot of things, and I'll get to that, but there certainly are some concerns. So when we are drawing from King, we are doing it when we interpret statute, in the context of directors' duties, when we are to some extent interpreting common law. And in all of this, we are aware of the fact that we must interpret all of this through the prism of the Constitution. But in the end of the day, King itself is not legislation, and the Act doesn't in fact give courts the mandate to take cognizance of it. And if you go to the ordinary rules of statutory interpretation, what you're really then doing is you are drawing from an external source to interpret this statutory provision. So if you look, for example, at more concretely at the how we look at the best interests of the company has always been interpreted by the courts with quite a firm emphasis on shareholder interests. The legislature didn't actually redefine that. And this is interesting because the Act was drafted after the 2006 UK legislation, where stakeholders are in fact expressly mentioned. Now, other than our Social and Ethics Committee, our legislature actually stops short of that. It doesn't redefine that term, and it doesn't tell us in the objects of the Act exactly how to engage with a variety of stakeholders. There is more precision and clarity, I think, in the context possibly of employees, but I do think the legislation stops short of embracing this pluralist approach that King has embraced. And we are warned and have been warned by the courts again and again that we cannot on a case-by-case basis subvert the plain meaning of a statutory provision. So going to another example, section 163 again, we have a body of case law dating back that refers to very particular circumstances. And this is what the legislature drafted that section in the context of that. And so I do think that there are some questions of interpretation that one must consider when reading in the codes. Then there are normative debates. Of course, there's a huge debate about whether this should be voluntary mandatory. Voluntary mechanisms have a lot going for them. They are responsive, they're industry driven. This signifies buy-in. They're quite cheap because it's usually, as I say, industry driven, which means it doesn't cost the taxpayer a lot of money to enforce them and so on. So a lot going for them. But of course, then they might not have the weight of legislation. And that's, of course, the approach that the Americans took with SOX. Now, SOX, which is mandatory, again, has a lot that you can say against it. It is costly and red tape, and you know, there's been a lot written about why that model is not ideal either. Then, of course, there's the broader question that the codes are really norm setting. This is a best practice, and is it realistic to measure all conduct against what is essentially, you know, the highest bar? There is also our attitude to regulation. This idea that a company is a nexus of contract and contractarianism that has really infused our company law for many, many years. And I think that still hamstrings how we regulate because it is just so entrenched. This quote is too long to read, and it sort of illustrates, I think, just well these attitudes. The writer here says, any attempt to rebottle a corporate genie in its original vessel is a futile exercise. And we should not feel hard-pressed as regulators to devise controls to restrain a spirit ominously unbottled. So this idea that the market and the forces that drive it really is too efficient and too complex for us to possibly regulate appropriately, and we should really just leave it to its own devices. And I think really we've reached a point, and a lot of scholars writing about enlightened capitalism, and as Professor du Plessis in his keynote mentioned in America, the roundtable, people are becoming alive to the fact that we really can't, we don't have the luxury of that. We have to somehow now get the genie back in the bottle, but we have to do this in a way that is most effective and most efficient. And so where to from here then? Well, I would argue that we must confidently embrace our unique context in South Africa and the opportunities that this context brings. We have a very unique constitutional dispensation and a modern Companies Act that I think leaves room for very interesting applications and dynamic shifts. We also have a trend-setting corporate governance code. And I think if we continue to work towards a dynamic hybrid that capitalizes most efficiently on these intersections, we will be doing ourselves a favor. I do think the ideal will be clearer reference to King in the Act and how the court should apply it. To date, it's been obiter, and I think there are a few problems with that. The first is that I think in many instances, we will be pushing and straining what statutory interpretation is actually allowing us to do. And also, it is an industry-driven document. And so I think norms and boundaries in how we read it into the legislation are perhaps appropriate, given that the courts would then almost be setting policy. If you are looking especially at small to medium enterprises and all the implications of pulling it into that sphere, I do think we need more guidance in the legislation. And I do also think that a clearer signal in the Act can go some way to changing hearts and minds. If we want to change boardrooms across the country, if we want to, I think in a way, liberate management as well, because management and the board needs to sell to its shareholders why they are taking certain steps. My corporate finance lecturer described transactions through the Act as a pinball machine. If you have a transaction, you throw it through the top in section 1, and it's going to run through the Act, pinging all kinds of different sections of that legislation. And while I completely concur that we shouldn't throw the baby out with the bathwater and that a whole-scale reconfiguration of the Act is not necessary, I do think if we truly want to integrate a stakeholder-based approach, we need to consider holistically how the Act scaffolds and frameworks this. And I know other scholars in the UK in particular, Professor Irene Marie Esser and colleagues have been looking at an integrated sustainability model where there are various parts of the company that all work together to build a structure that can best accommodate stakeholder interests. And that would include a dynamic integrated social and ethics committee. It would include the way that we read King into directors' duties if in fact we decide that it is normatively the way to do it. And so it is all part of, I think a bigger inquiry that answers what is this vaccine? What are the ingredients of this vaccine that will maybe rid us of these viruses of greed and inefficiency and the like. And I think part of that is this inculcated belief holding us captive that that we shouldn't meddle, we shouldn't regulate, and I think we can move away from that towards a holistic, integrated approach, which is likely the only answer. King can be a key in that, but I do think we can do more to create legal certainty, very importantly, in how we apply and use it and reference it, and to exploit its strengths. And I do think you then have to look at other sections in the Act, like the fundamental transaction provisions and so on, because shareholders can at this point still block directors if they want to enforce a sustainability agenda or a stakeholder friendly agenda. And so it is one thing to say that we can interpret the Act in this stakeholder friendly way, and something else when the rubber hits the road and directors find themselves up against a wall, and you still have a court interpreting this with this dominant backdrop of capitalism or profit maximization. So I think the legislature can possibly do much by including a clear signal that we are moving beyond that. And I don't think this needs to be a rigid, overly complex bureaucratic system like SOX. I think we might have the best of both worlds here in the legislation dynamically working with King. Thank you all very, very much. I must again apologize for my tardiness, and thank you very much. It's been a privilege to address you today.
Thank you very much, Helena. Thank you very much also for coming up with a plan B so that you could be able to join us. Thank you, really. We really appreciate all the efforts that you colleagues are making so that you can be able to join us on this conference. For now, I don't know, colleagues, are there any questions for Helena? Any questions for Helena? I do not see anything in the chat. Perhaps we could have some participants unmuting their microphones. Okay, we have one question from Prof. Mongalo. He says, why is it a good thing to continue with a self-regulatory code of governance that is recognized in case law, but you are against SOX?
Thank you very much for the question, Professor Mongalo. I think because this is quite different from SOX, I think a lot of the problems inherent in SOX can be avoided because you would still primarily have a voluntary code of governance. And that's why I think it is a good idea and ideal for the legislature to give concrete and clearer guidelines. At the moment, it's just really unclear. If you are a private company, is this now your legal duty? And if it's your legal duty, to what extent? And will the courts read it in or won't they? And if so, to what extent? So I do think that this hybrid might give us a compromise. It is not quite SOX, but it does open the door for a more nuanced and a more progressive interpretation of the legislation. So I think we just need to accommodate that intersection possibly more efficiently, because at the moment we have this, I think, unideal scenario where the courts are referencing it, but it's relatively haphazard and haphazardly done. So I don't think this is the same as SOX. I think it retains all of the benefits of an industry-driven code, the fact that it can be flexible, responsive, and so on and so forth.
Thank you very much, Helena. Thank you very much. We appreciate that feedback. And this concludes this session, session 2 of this conference. I am going to hand over now to the next chair, that is Dr. Killian, to talk to us and help and chair the session on practical tips on book publication. Niels, over to you.
Thank you very much, Melu, for introducing me. I think we have Professor Howard Chitimiro that will be explaining to us how to publish textbooks and books in South Africa. First of all, we received an apology from Professor Ruth Taplin. Unfortunately, she cannot make. In this regard, Professor Chitimiro, he will stand in and present how to publish tips and advice. Thank you very much. Thank you, Prof.
Thank you, Chair. Colleagues, can you hear me?
Yes, Prof, we can hear you.
Thank you. I was hearing some echo, I think, from myself. But now it's clear. I have to echo what Dr. News is saying. We are very much in difficult circumstances due to the times we are living in. So Prof. Taplin has everything done and all was in place. But, you know, the pandemic is a challenging one. She has a serious health challenge. She can't. So she asked me to stand in for her. I must make sure that you know that I can't fill her shoes. She is very much experienced in book writing, but I'll do my best to share the experiences that I've learned from her and other colleagues. So the title here is Practical Tips on Book Publication. We are trying to help ourselves and colleagues here about what to do and not to do during the processes. So the structure, we're gonna talk about the introduction. What do we have to do? The tips on what to do, the tips on what to avoid, and then we conclude, hopefully to be shorter. The rationale for these colleagues is, why are we having this in the conference? We have had many requests from colleagues who wrote to me specifically about, hey, we need a session for mentoring. We need a session on how to do things. So I came up with an idea of having a session of experienced colleagues to come and talk to us. That's why we engaged Prof. Taplin. We have written over 25 books with Routledge and other publishers. Unfortunately, she couldn't join today. The rationale here is to encourage colleagues on how to write academic books, also to help colleagues with their books and related projects. We are also trying to establish a platform that is a free one. We don't pay, but we are part of the team. A collegial academic mentoring platform where people will come with various ideas we share regarding our research, especially on book publication processes. So I'll start with what to do, the practical tips. The first one, most important for one to start, especially when you're dealing with a book, it's different from an article. You need to understand the purpose. What really are you trying to write, and why are you writing it? What do you want to do? What do you want to accomplish? What do you want to achieve at the end of the book? So what do you hope people will learn, or students, if it's for students, if it's for policymakers, what are you trying to do? So those are the key things. Understand the purpose of the book. You don't write for the sake of writing. You want to know, is it addressing a political challenge? Is it addressing a current pandemic? For instance, now COVID-19, is it addressing any maybe a religious matter or a sensitive one? It all depends on the purpose of the book. So the second important thing is, now you need to recapture and imagine your audience. It's all part of planning and writing a book. What is your audience? There are many things here we simply summarize. You look at the age. A book that is written for preschool definitely cannot be the same for high school. It can never be the same for tertiary or university. So the age plays also in the level of education of your audience, the values that they value. If you are writing a book to a Christian society or non-Christian society, to an educated society or a primitive society, all these things comes in. So they determine in short, how much the audience know already on what you are doing. It helps you to determine the tone in the book, the content, the style, the layout itself, as well as the type of book. Is it a research book? Is it an academic for, like, you know, a textbook? It's for people to engage with it. A research book and a textbook is different. A children's book is also different. A sports book, there are various types of book. This also comes in. Okay, the third most important thing is you need, as an author, to know the area that you are writing about. I'm quoting here James Morton, who says, I open quote, if you know about ice hockey, don't write about butterflies. I think this is clear to everybody. In other words, if you are more comfortable with computers, expand it in computers. If you are knowledgeable about constitution, you can add more value around the constitution. If you know more about maybe counseling in church, about marriages, whatever, focus there. You greatly improve people in the area that you know about. So one needs to know about what you are writing about. Write about what you know. Don't try and reinvent the wheel. It's always good to start something new, but risks are there. You end up sometimes creating more questions or errors. I'm not trying to scare people to venture into. If you have limited knowledge in an area, that's why we have co-editions or edited books. We are trying to put our minds together because there are various types of book, an individual book or a one that you do collectively with others. We are trying to cross-pollinate ideas. So we cater for things like this. If I have limited knowledge in terms of maybe law of property, or let's say law of insurance, and I know there's news here, and there's Klopas who is here, or somebody else, if I'm wise, I want to tap in from them, I bring in, I have an idea, but you see, we help each other. The fourth important thing here is you do your research. After you have identified and understand the purpose, known your audience, you have some knowledge about the area, the work starts. You have to collect the data. Research means you do research and you redo it again. From research, you search and research. So it's a lot of work. Before you start writing, thoroughly read, understand all relevant material. It's very difficult to write about something that you yourself don't understand. You spread confusion to others, and the book won't be really a success. The objective won't be achieved, and before you know it, you'll be discouraged. So try and do your research adequately, read thoroughly, understand all relevant to the area you're writing about, all relevant material. The fifth thing that I think people should do when writing a book, you must work from an outline, create your own. You know how you work. You know the times that are good for you. Some are good in the morning, some are good any time of the, they can write even in a car, they write anyway. But some of us, some need outline, some don't. They have everything figured out in the heads. But I encourage people to organize their research into an outline. It will always help you to know when to put a conclusion or an introduction. If you do it haphazardly, chances are you write a conclusion before, and then you remind yourself, oh, a reviewer say, but it appears there is no introduction. You have just, hit it from everywhere. So get an outline. And the sixth one is you need to be disciplined. Once you have set an outline, stick to it, keep your writing focused and organized. Don't underestimate the time required. Writing a book, you believe me, it's more rigorous than writing an article. So it is a lot of things that are involved in. But if you've done your research and you've put everything together, you realize that you give yourself practical timelines that you have now to stick to them. If you miss one, try and create time to be in your schedule. And one is to be also clear. The seventh one is be clear and use good content to sell your views. The idea is always to communicate. We communicate verbally, we communicate also through books. So one is to put in the message to others. It might be a new concept, it might be an old one, but you are trying to put it in your own view. So make the reader understand your arguments. You don't have to be emotional about it. You don't have to be difficult about it. You simply have to communicate it to the person that is going to read your book. Even those who are not in your area, that whoever read it, even if they are not maybe lawyers, if it's given to an accountant, they can get an idea at least of what this lawyer is trying to say. So make reader understand your arguments. You do it through content. You sell your views through clear understanding or clear language that you use in your writing. And that after this, the rework, they have to start. Starting is very difficult, but people are very much, I've seen from my own experience, people are scared of writing a book. They always think, what if I fail? What if that? But I'm saying to you, colleagues, don't worry about getting it perfect for the first time. Try. There's always good to try. And you perfect it as you go. That's why we do editing. That's why there's need for proofreading. So as you go in, the key thing is to set the ball rolling. Start, and then you perfect it as you go. That's why we have editors. That's why we have maybe grammatical people to look language editing, etc. So get started. And once we have started, one is now to use relevant language and appropriate jargon. I've used an example earlier on that if you're writing to a grade R class or those who are, in creche or toddlers, the language that you're going to use there is not the same as the way you're talking to university students. So use appropriate jargon to the audience that you are addressing the book to. Avoid as much. I know we are lawyers. Most of us, we want to, express it that people know that I'm a lawyer. It's good sometimes, but sometimes it's not. Too much technical law language makes everyone confused and you don't say your ideas well. So avoid legalese, avoid being the boss. We don't necessarily have to have a dictionary, to understand what you're trying to do. Use plain language. Simple English can get the job done. The other point, number 10, is a good book should be edited properly. You should proofread your own book and also allow another person to read your book to tell you about what they are seeing that you might not see as a reader. You can also make use of helpful tools, apps. Nowadays, we are living in fourth industrial revolution and technologies everywhere. There are various tools that one can use for editing to detect errors, even plagiarism. So edit your work, proofread it thoroughly, and then you minimize a lot of common mistakes that you do that you might find in a book. A book is a bit bigger than an article. So imagine if you have 500 words from page 1 to the end, it's full of errors. You would have created a lot of mistakes in it, which you could avoid. So with some thorough editing, proofreading, and relevant use of tools to help yourself, the book can be in a much, much better way that people will read it and understand it without frowning. Okay. The other tip that I can give here is we need, when you are writing a book, normally, I know people sometimes do what they call self-publishing, but I think we need to identify and maintain a good relation with a credible publisher. Here I'm trying to say avoid predatory publishers. There are nowadays, in our time, there are various outlets, publishers, they can publish the next second it's out, it says a ISBN number, it's already a book. Avoid temptation to run for quantity and run for quality. And once you have a good, credible publisher, manage the relationship thereof very well. They have their terms, you conform to their terms, you have your own rights, they have their own rights, you work as a team, as a family. Okay, and then the marketing of the book, blogs, social media, digital platforms, book launches, library, bookshops, all these are there to market that book. Okay, let me move on to what we should avoid. Then I'll conclude because I think I've left with a few minutes. I think the most important thing in any academic writing is to avoid plagiarism. If you are citing, make sure it's accurate. Credit is supposed to be given where it is due. Reference all sources, and your referencing can only be good if it's accurate. Reference well the name of the person. If it's Howard, let it be Howard. Don't create another name, because once it's inaccurate, it's already amounting to plagiarism. Avoid unethical conduct. Stick to the law or area that you are writing to. There are various rules for research, relevant academic and research practices in your area that you are writing. If it's a law book, stick to what we do as lawyers. If it's in education, the same. There are various research practices that are there in any area that one can write a book on. And then the other thing that we should avoid is, I've already said it, predator publishers. We should focus on quality, not quantity, not speed, because quality is key. We are not rushing to get 10 books or 50 books in a year. We are trying to set a message and communicate and add knowledge, add or contribute to knowledge, not necessarily. So be careful when you select your publishers. Be very careful. Research about them, check their websites, check their books, check their reviews. Be very wise to avoid wasting your time with people that really are not publishers of reputation. Don't violate copyright laws. We write and we are governed in most cases by copyright laws of various countries that we write in, and they are what we call publisher contracts. Stick to them. Don't violate. If they give you a soft copy or whatever it is, they say this is for use. You don't need to try and reuse it in your own way. You have problems. And the last thing I want to say on don'ts: avoid defamation, avoid conflict, have integrity, be honest, be truthful. Share your views carefully. You don't need to, overbeat your own drum or try and make your views in a way that will affect others. We have freedom of expression, but you must do it carefully to avoid infringing on other people's rights. In conclusion, colleagues, I hope we are encouraged to write academic books and to engage more in academic writing of different types, be it for research, be it a textbook, be whatever way you want to do. I want to close in, and on behalf of the conference team and Prof. Taplin, thank you very much, colleagues. Okay.
Thank you very much, Professor Shitimiro. Are there any questions? Questions in the chat? Anyone with a question? Okay, then thank you very much. Pumelo, I just want to know, are we breaking for lunch? Or is it not yet time for lunch? It's now 20 minutes past 12.
Thank you very much, Dr. Killian. Thank you very much also to Prof. Chitimira on the insights on what to do and what really not to do when one considers writing a book. That presentation, we found it to be quite helpful and useful, especially to us emerging academics. Thank you very much. Yes, I think, colleagues, we are going to break here for now for lunch, and then we will come back again at 1300 hours. But we will leave the session will be on. We will leave the meeting will be on, but we are going to come back at 1300 hours. Those who want to log out to save data, they are welcome to do so. But if you want to stay in, you are also welcome to do so. We are coming back at 1 o'clock, 1300 hours, South African time. Thank you very much, colleagues.
Thank you, Pumelo. Thank you.
We are still in the grips of the COVID-19 pandemic, in the course of which the economy contracted by a massive 6.4%, and 1.4 million jobs were lost. The legal principles relating to corporate insolvency grow in importance and become more acute as companies struggle to cope with the financial crisis caused by the COVID-19 pandemic. Two aspects in particular
Prof, are you still there?
I think his connection might be giving him some problems.
Yep, it looks like that. And I do see an indication of some who are saying they cannot hear. Yes, we have lost connection insofar as Prof is concerned. Maybe you can give us direction on what course of action to take next.
Thank you.
Wallace, yes.
Thank you very much, Dr. Warikonda. I think let me just see on the program, because after Prof. Kasim, it is supposed to be session 3. And I see that, I think let's proceed to session 3 in the interim, and if Prof comes back, we will slot him in.
Okay, then it's over to Dr. Ahmad Ziripi.
Sorry to interrupt. Prof. Kasim is on his way back. Just a slight connection problem. He'll be back in a few seconds. Sorry about that.
Okay, no thanks.
Thank you so much.
Over to you, Dr. Harigwanda, once again.
Right, thank you. As we just wait shortly for Prof. Kasim to reconnect. Okay, Wallace is reconnecting. Maybe I can just go in fuller detail in terms of his resume. Wallace is reconnecting. Of course, like I indicated that Prof. Kasim, of course, studied at the London School of Economics and Political Science. Prof, are you back?
Hello.
Yes, okay, go ahead, Prof.
Hello, can you hear me now?
Yes, we can hear you, Prof. Thank you. You can go ahead.
Just adjust the volume. Adjust the volume.
Then how does it can go? You can't hear.
We can hear him. I'm sure he can go ahead.
Okay. Can you hear me now?
Perfectly well, Prof. You can go ahead.
Okay, thank you. I don't hear you too well. The connection doesn't seem to be too good, but stop me if I'm becoming inaudible. As I was then saying, that there are two aspects in particular that become prominent in times of financial crisis. And these are firstly business rescue and Section 22 of the Companies Act of 2008, which prohibits fraudulent or reckless trading. During this difficult period, companies globally have had to make pivotal and far-reaching decisions on a wide range of issues, such as the management of their cash flow, their redundancy procedures, and the giving of financial assistance to associated companies in company groups. Crisis legislation to assist companies has been enacted in a number of countries, such as the United Kingdom, Australia, New Zealand, Malaysia, Singapore, and some European countries. Such crisis legislation has tended to apply in 5 main fields. Firstly, extending the filing periods of audited financial statements. Secondly, permitting virtual shareholder meetings and online proxy voting. Thirdly, permitting voting by email. Fourthly, granting relief on statutory formalities protecting shareholders, such as extending notice periods for shareholder meetings and for the approval of certain shareholder resolutions. And fifthly, amending the statutory provisions regulating distributions and to accommodate changes to the liquidity and solvency of a company caused by the global pandemic. In Australia, for instance, legislation has been enacted to make permanent the temporary measures to permit the electronic execution of company documents and the holding of hybrid virtual meetings. In contrast, we in South Africa have been lagging behind. Although there already is provision in Section 60 and Section 74 of the Companies Act of 2008 for round-robin shareholder and board resolutions and for virtual shareholder and board meetings, the regulator, that's to say the Companies Commission, or if you wish, CIPC, needs to be more active to ensure there is more flexibility in the application of the formalistic statutory provisions relating to shareholder meetings, notices, and financial reporting requirements. As we do not have any equivalent crisis legislation in the field of company law, we have no choice but to rely on judicial and regulatory pragmatism. COVID-19 has pushed many companies to the brink of insolvency. Some have shut down completely, while many have resorted to business rescue. In insolvent circumstances, the interests of shareholders, creditors, and employees tend to diverge. But in considering the best interests of the company, the directors of the company remain under a legal duty to consider the whole spectrum of the interests of shareholders. Although there is common law authority for the view that in a near insolvency situation, the directors come under a duty to act in the interest of the creditors of the company. The Companies Act in Section 76(3)(a) and (b) imposes on directors a duty to act in good faith for proper purposes and in the best interest of the company. Directors must also exercise reasonable care and skill in the performance of their duties and functions, although the extent of this duty is somewhat attenuated by the business judgment rule. Be that as it may, in South African law, the statutory and common law fiduciary duties remain the same in the pandemic. There has been no change in these duties as a result of the COVID-19 pandemic. Closely linked to the statutory and fiduciary duties of directors is Section 22 of the Companies Act, which prohibits a company from carrying on business recklessly, with gross negligence, with intent to defraud any person or for any fraudulent purpose. Section 22 must be read with Section 77, subsection 3b, which imposes personal liability on directors for loss, damages, or costs sustained by a company as a direct or indirect consequence of the director acquiescing in the conduct of the company's business despite knowing that it was being conducted fraudulently or recklessly. I do not have the scope in this very brief presentation to do an in-depth analysis of fraudulent or reckless trading. Suffice it to say that Section 22 draws a dichotomy between fraudulent and reckless trading. Recklessly, in contradistinction to the word fraudulently, has been defined by the courts to mean gross negligence. And although gross negligence by its very nature is a very difficult very difficult concept to define, it refers to conduct that evinces a lack of any genuine concern for the prosperity of the company. Dishonesty is not an essential element of recklessness, although it is for fraudulent trading, and the good faith or bona fides of the directors is irrelevant. Reckless trading requires more than a mere error of judgment or ineptitude. As a broad general principle, when a company knowingly continues to carry on business and to incur debts when there is no reasonable prospect of the company being able to pay its debts, it will be a proper inference that the business of the company is being conducted in contravention of Section 22. Depending on the facts and the circumstances of the case, it could even be fraudulent rather than reckless trading. Now, apart from personal liability for the damages suffered by the company, the errant or culpable directors could also be declared to be delinquent directors. And fraudulent trading, though not reckless trading, is a criminal offense. The draft version of Section 22 had originally prohibited a company from trading under insolvent circumstances. Trading under insolvent circumstances is not necessarily fraudulent trading, although it could constitute reckless trading. The draft version was, however, amended. Section 22, subsection 2 now provides that if the Companies Commission has reasonable grounds to believe that the company is conducting business fraudulently or recklessly, or that it is unable to pay its debts as they mature in the normal course of business, the Companies Commission may issue a notice to the company requiring it to show cause why the company should be permitted to continue carrying on business or continue to trade as the case may be. The test posited by Section 22.2 is whether the company is commercially insolvent. For the purposes of Section 22, subsection 2, balance sheet insolvency, that's to say liabilities exceeding assets, is irrelevant. Commercial insolvency is simply illiquidity or cash flow problems or an inability to pay debts as they mature. Section 22, subsection 2 is designed to ensure that the directors of a company do not irresponsibly incur debts at the expense of the creditors at the time when the company is in the near insolvency situation and payment to the creditors is doubtful. According to section 22, subsection 3, if the company fails within 20 business days to satisfy the company's commission that it is not conducting business fraudulently or recklessly, or that it is able to pay its debts as they become due and payable in the normal course of business, the company's commission may issue a compliance notice to the company requiring it to stop trading. The consequences of failing to comply with the compliance notice can be quite severe and could result in a fine of 1 million rands or 10% of the company's turnover during the period that the company failed to comply with the compliance notice. On the 24th of March 2020, the company's commission issued a practice note stating that for the time being, it would not invoke its powers under section 22, subsection 2 and 3. It would not issue compliance notices to companies that are trading in the circumstances prohibited by section 22. This is only a temporary reprieve that will automatically lapse within 60 days after the end of the declaration of the national disaster. The scope of this temporary reprieve is narrowed down further to apply only to companies that are in temporary insolvent circumstances arising from the COVID-19 pandemic. I must emphasize that this temporary reprieve from section 22, subsection 3 originates from the company's commission, which is only a regulator and not a legislator. This means that the company and its directors are not released from their statutory duties under section 22 and section 77 3B. The directors of the company could still, in law, incur liability to the company for the fraudulent or reckless conduct of the company's business. The CIPC, the Civic Practice Note, does not go far enough to offer meaningful assistance to companies in financial distress as a result of the COVID-19 pandemic. It pales into insignificance when compared to other jurisdictions. To take just two instances to illustrate my point. First, in England, the Corporate Insolvency and Governance Act of 2020 suspended, with effect from 26 June 2020, the law relating to wrongful trading, which is roughly equivalent to our fraudulent trading offense. This new statutory provision applied during the period 1st of March 2020 to 30th of September 2020. This means that, unlike South African law, if the directors of an insolvent company raised credit for the company when they knew that the loans raised by them could not be repaid, they would, under English law, incur no liability for wrongful trading. In striking contrast, in the same circumstances in South African law, the directors would not only incur personal liability to the company for fraudulent trading, they could be committing a criminal offense and could be declared delinquent directors. The second instance is New Zealand, where new legislation was enacted to provide, with effect from the 3rd of April 2020, temporary relief for a period of 6 months for directors of companies from their duty not to trade recklessly. The directors must have believed in good faith that the company would, within 18 months, be able to pay its debts as they fall due. In South Africa, in South African law, directors are best advised to regularly monitor and evaluate the company's financial status to determine its solvency and liquidity. They must be careful not to contravene Section 22 by persisting in the company continuing business in the hope that the company will be able to trade out of its financial difficulties. If the company is in near insolvency circumstances, the most appropriate step to take would be to place the company under business rescue, provided that the company is still a commercially viable entity. The company would thereby obtain the benefit of a temporary moratorium that freezes the enforcement of legal claims and remedies against the company until a business rescue plan is implemented by a business rescue practitioner. Since the successful rescue of a financially distressed company is good for the economy and could result in saving jobs, the judiciary—
4 more minutes, Prof. 4 more minutes.
Thank you. The judiciary must be flexible in the application of the formal statutory requirements with the short prescribed time periods laid down for the business rescue process. Yet, paradoxically, exactly the opposite approach seems to have been adopted by the company's commission in the business rescue application of Mango Airlines, a state-owned entity with 700 employees that was crippled by a huge debt as a result of the COVID-19 travel restrictions. You will recollect that during the hard lockdown, flights were suspended. The problem in this case was that the Companies Act requires that an application by a company to be placed under business rescue must be filed with the Companies Commission within 5 business days after a board resolution to place the company under voluntary business rescue. Astonishingly, if not shockingly, the Companies Commission rejected the business rescue application of Mango Airlines on the ground that Mango Airlines had filed its application 3 months too late, and also because liquidation proceedings were pending against it. Instead of easing the regulatory burdens on Mango Airlines, the Companies Commission insisted on strict compliance with the formal statutory requirements of the business rescue process. The court, however, sensibly and commendably set aside CIPIC's refusal to accept the board resolution of Mango Airlines to be placed in business rescue. In conclusion, then, some foreign jurisdictions have already started to repeal or dismantle the crisis legislation they had enacted to assist companies during the global pandemic. Sadly, in South Africa, we have done very little in the field of company law to assist companies facing insolvency as a result of the COVID-19 pandemic. It is, however, in my view, still not too late to relax the regulatory burdens on companies in order to assist them in these difficult times. Thank you.
Thank you very much, Prof. Quite a profound presentation indeed, well-rounded, particularly when we look at issues around business rescue. Thank you very much. Colleagues, if there are any quick comments or questions in the next minute or two. On the chat, I don't see any hand or comment for Prof. If there's no further comments, thank you very much, Prof, for your profound presentation. Much welcome at this particular point in time. Of course, I was going to ask a question in terms of the efficacy of business rescue under the circumstances, but I think it has already been asked beforehand by another party. So I think I'll hand over to the chair for the next session. Thank you.
Thank you.
Thank you so much, Dr. Warkandwa. We are moving on to the next session, that is session 3, company law, corporate governance and practice. All the speakers in this session, you have 15 minutes. Then after that, we shall have a question and answer session for 15 minutes as well. So this time I'm going to leave it to the first presentation in this session, which is by Dr. T. Kondo and Miss Jonas from the University of the Western Cape. And the title of the presentation is An Analysis of the Zambian Foreign Investment Regime, Challenges and Opportunities. Over to you, Dr. Kondo and Miss Jonas.
Thank you. Good afternoon, colleagues. I'm Dr. Kondo, and I'm here with Miss Angela Jonas, a fourth-year student at the University of the Western Cape. We are going to be making a presentation titled An Analysis of the Zambian Foreign Investment Regime, focusing on the challenges and opportunities. I'll hand over to Miss Jonas for the presentation.
Good afternoon, everyone. My name is Angela Jonas, and I will proceed with the presentation. Zambia has, over the past few decades, attempted to attract foreign investments into its shores. The attractiveness of Zambia as an investment destination is determined by a number of global factors when investing, which includes key issues such as the policy, legislative, and institutional frameworks. There are other factors that are considered, such as the ease of doing business, democracy, macroeconomic instabilities, political stability, and corruption. Although there has been several key drivers of foreign direct investment in Zambia over the years, it can ultimately be concluded that Zambia has not been a favored investment destination. FDI has been concentrated only in a few sectors, with the most investment going into the mining sector. It is for this reason that it becomes important to provide an FDI review in the Zambian context, because while opportunities for all the countries to attract investments are not equal, setting up the right systems to attract investments does not improve the standing of the country. Ultimately, the paper focuses on how investment can be improved while balancing the regulatory space for the Zambian government. Zambia gained its independence in 1964, allowing the establishment of its economy. Subsequently, it created a platform for the increase of the country's FDI. The Mulungishi reforms came into operation in 1968 under the presidency of Kenneth Kaunda. The reforms served the purpose to nationalize private-owned companies, where the government nationalized a wide range of commercial activities such as retail chains. Notably, the reforms excluded mining companies. The state later introduced the material reforms that included the nationalization of mining companies. The parliamentary passing of the Privatization Act 21 of 1992 served as the legislation which gave rise to the Zambia Privatization Agency Act that acted as the institution reliable for the divestment of state-owned companies. The ZPA would be governed by a board of directors made up of individuals from the private and public sectors, which officers were chosen to run the agency. The LACTA Act provided for the privatization of state-owned companies that actively contributed to the economy through mining, manufacturing, trade, and service delivery. It aimed at attracting local investments and FDI. As amended in 1996 and 1998, the Investment Act of 1993 encouraged foreign direct investment in productive sectors. According to Article 16, subsection 1 of Zambia's Constitution and the Investment Act, investments are protected against forced acquisition except for public purposes authorized by an act of parliament and from prompt compensation. As a further incentive, Zambia launched the Private Sector Development Reform Program in 2004 that increased private sector's contributions to the economy. As it stands, investment in Zambia is ruled by the Zambia Development Agency Act of 2006, and additionally, legislation is found in other acts such as the Company Act and the Competition Act. The Constitution of Zambia also holds laws on promoting and protecting investment in Zambia, including protection against expropriation. In relation to the investment trends in Zambia, although there is overall data on investments in Zambia, there is not a lot of data in terms of sector-specific data. Another challenge with regards to the data available is that the investment data from the Zambian investment sector contains a lot of investment pledges and not actual investment. A lot of investment in Zambia, especially in the 1990s, actually consisted of takeovers of retail businesses and privatized parastatals and not actual greenfield investments. Before the early 1990s, there was very little investment in most sectors in Zambia, including the mining sector, which is the main investment sector in Zambia. Investment was also affected by the nationalization of key sectors in the economy, including mining in the 1970s. This was inspired by the Mulungishu reform, where the government announced its intention to acquire 51% of the holdings in a number of key foreign-owned companies. However, in 1992, the government started a privatization drive which improved investment inflows. The drive brought to an end the era where over 80% of the companies in Zambia were state-owned. The mix of companies owned by the state shockingly included mines, supermarkets, hotels, and financial institution services, of which are generally provided for by the private sector. Overall, the changes to FDI are not significant given the size and the level of the economy, as well as the population size when compared against similarly situated countries. Zambia's performance has been poor, and perhaps one of the key challenges is the non-diversification of the economy. As it can be graphically depicted, there's a link between FDI in Zambia and the copper world flows. This depicts the reliance of Zambia on mining investment, especially copper investment. There are, however, still other investment opportunities, including agricultural processing, infrastructure, tourism, technology, e-commerce, energy, and petroleum. The successes in Zambia is that Zambia has joined a number of regional economic communities, such as the SADC and AFCFTA. These RECs are important for building regional economic integrations. Zambia has offered a number of investment incentives through the Zambia Development Agency Act, which includes allowances, exemptions, and concessions for companies. The government has begun to remove some regulatory barriers. For example, in the telecommunications sectors, the government has started to relax measures to allow for participation. The challenges include that fiscal incentives are only given to a certain category of investments, where only investments of more than $500,000 and above in a MFEZ, an industrial park, a priority sector, and a rural enterprise under the ZDA Act are eligible for this. Investment incentives granted are not attractive enough, as Zambia is competing against other countries such as Rwanda that provides tax incentives of up to 70%. The government is also reluctant to give custom incentives. The MFEZs have not been utilized to their best abilities, and these need to be further enhanced in the future. There's a further restriction of investment opportunities, such as the red tape bureaucracy, due to the fact that it takes a long time for the investment licenses to be granted, which could take anything between 60 and 90 days. The regulation of the FDI in Zambia consists of customary international law, which is generally binding on all states. Customary international law comes from general principles in international investment that have been generally accepted as law. Zambia is a dual state and views domestic law and international law as two separate systems. Therefore, domestication of international law by an act of parliament is required before any international law can be applied. Nonetheless, Zambia's constitution provides in section 10, subsection 1, that the government shall not compel to require an investment except under customary international law and subject to article 16, subsection 1. In terms of bilateral investment treaties, which according to the data from UNCTAD, Zambia has signed 16 BITs. Of these, only 7 are in force. The challenges with these BITs, as with most from developing countries, is that they do not balance the rights and obligations of investors and host states. The treaties provide for the typical provision found in the first generation BIT, such as definition clauses, fair and equitable treatment, national treatment, fair equitable treatment, subordination, state-to-state dispute settlement, investor-state dispute settlement, permits, repatriation of funds, transparency, consultancy, and entry into force. Regional trade agreements with investor provisions. Zambia is a part of SADC and the AFCFTA. SADC has recently reviewed its protocol on finance and investment, and it now provides for more balanced provisions. However, Zambia has not reviewed its BITs and domestic law to reflect this. The challenge is therefore that there is a diversion of provisions at the various levels. Moreover, under the AFCFTA, the protocols on investment is still being negotiated. Zambian Development Agency Act, while it is commendable that the Zambian government has enacted this act, there are a number of shortcomings. The act, for example, provides typical unreformed provisions that are seen in the first generation BITs, and the act also does not clarify a number of issues. For example, in its scope of application, there is no distinction between natural and juristic persons with regards to its application. Other challenges include the use of terminology such as adequate compensation with regards to compensation for expropriation, as opposed to using a flexible criterion such as that utilized in South Africa. The Act does not address very important issues such as that of indirect expropriation that has become important, especially in the implementation of the right to regulate and the maintenance of policy space. This is, however, a very court-based process and does not account for issues such as international arbitration and whether it is a remedy of last resort and what happens to investors protected by the treaties. Reforming the
2 minutes left.
From the discussions above, it can be noted that Zambia has made significant progress in developing the investment framework. Coming from a history with challenging practices such as nationalization, expropriation, and majority ownership by the government in many sectors, there has been significant changes. This has been witnessed through the setting up of policies, institutions, and legislations. However, there are many shortcomings, particularly with regards to the legislative aspects. The ZDA Act is outdated and is in need of significant reform. We are aware of the fact that the Ministry of Trade has already initiated the process of review, and therefore the contribution of this paper is timely. The ZDA needs to be amended in order to balance the rights and responsibilities of investors as discussed in this paper. There are certain clarifications that are needed in this act in order to remove doubt as to the interpretation of some provisions. The role and form of the BITs need a lot of thinking. It may be necessary to terminate the BITs since there are only 7 in force. The benefit of BITs is still heavily contested. The scattergun approach where different provisions are dealt with in different documents need to be dispensed with. Investor incentives also need to be rethought in order to make the country more competitive on the international scale. The Act itself is not well organized and tends to be a bit vague at many points. This needs to be attended to. By large, there is a need for an overarching philosophy that guides the legislative regime. It is our suggestion that the principles of social justice, decolonization, Africanization, and digitalization is implemented into the current practices. Thank you.
Thank you so much. All those with questions, can we write them in the chat box? We shall leave time for questions and answers at the end of the session. Now we are moving on to the next presenter, and the title of the presentation is Corporate Governance, Less is More, from Mr. Schumann from the University of Limpopo. Apologies if I didn't pronounce your name well. Over to you, Sir.
Thank you. If I can just share my screen as well.
Dr. Kondo, may you kindly cease sharing your screen so that the next presenter can share his screen? Yes, you can proceed to share your screen now.
Thank you.
Later.
All right, I don't know whether the slides are showing.
We don't see your slides yet. We just see your screen.
May you go to the taskbar and click on the PowerPoint. Yes, and may you enlarge. Thank you.
All right, it appears that it has now already started, unfortunately. Let me just okay, is the
Are you still there? Yellow, are you still there?
Dr. Amaziriku, I
Hello,
think
Prof.
until he's found his footing, let's go to the next presenter.
All right, thank you.
Allow him to get the slides. Thank you.
Thank you. We shall move on to the next presenter in the meantime, as we wait for Mr. Schumann to fix his presentation. Let's move on to Miss Kazangarare from Leicester University. And the title of your presentation is The Challenges That Are Posed by the COVID-19 Pandemic on the Duties of Directors and Director Accountability. Over to you, Ms. Kazangarare.
Good afternoon, everybody.
I hope everybody can hear me. So my presentation is going to be on the challenges that are posed by the COVID-19 pandemic and the duties of directors and director accountability. In this presentation, I will discuss the duties of directors, director accountability, challenges posed by the COVID-19 pandemic, COVID-19 and the role of directors of companies, and the new act which was put in place to assist directors of companies during the COVID-19 pandemic. So I'm going to quickly just give a few definitions of the key terms that I will discuss in this presentation. A director includes any person occupying the position of director by whatever name called. So directors act as the supervisory organ of corporations, and as such, directors play an integral role in their companies. The duties of directors as stipulated by the UK Companies Act 2006 are fiduciary responsibilities held by company directors, which require them to live up to a certain standard. And then accountability is an obligation or willingness to accept responsibility or to account for one's actions. Thus, accountability is considered as an icon of good corporate governance. This is because accountability is seen as something that is good and commendable. COVID-19 has without a doubt caused several challenges in the world order, particularly people's lives, economies of countries, and has introduced what is now being called the new normal. This new normal is characterized by an increasing complex set of pressures and demands from various stakeholder groups. These pressures and demands complicate the ability of a director to perform their duties. As the COVID-19 pandemic has become more prominent, boards and directors of corporations have entered uncharted territory as the pandemic continues to present many challenges to directors in their efforts to strike the right balance between fulfilling their duties and allowing management to run the day-to-day operations. The COVID-19 pandemic has induced restrictions and consequent hardships for many businesses across multiple sectors, and company directors increasingly face the risk of criticism and inadequacy of their performance. Nevertheless, the COVID-19 pandemic proposes undeniable opportunities to advance research on corporate governance, particularly in matters pertaining to decision-making, survival, and the success of the corporation. This is because already the COVID-19 pandemic has begun altering corporate governance management, and as such, this pandemic has proven to be a game changer. The duties of directors. For nearly as long as the public corporation has existed, scholars, practitioners, and policymakers have debated the job description and legal obligations of corporate directors. This is because directors have the ability to ensure sustainability of the company, as well as the fact that they play an integral role in all company decisions, being that they're involved in inter alia, monitoring, decision-making, agenda setting, and risk assessment. I'm going to briefly talk about the duties of directors as per the Companies Act 2006. The duty to act with powers. So a director of a company must act in accordance with the company's constitution and only exercise powers for the purpose for which they are conferred. And the duty to promote the success of a company. A director of a company must act in the way he considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole. So in my opinion, this duty is the most important of the duties of directors. This is because this duty highlights the need to consider the wider reaching long-term impact that directors' decisions may have on employees, suppliers, customers, and the surrounding community and environment, rather than the more traditional approach that focuses solely on companies' shareholders. The duty to exercise independent judgment. A director of a company must exercise independent judgment. Hence, the rule applies irrespective of the circumstances in which the director has been appointed. The duty to exercise reasonable care, skill, and diligence. A director of a company must exercise reasonable skill, care, and diligence. This duty of skill and care puts existing negligence law onto a statutory footing and provides that a director must act with the care, skill, and diligence that would be exercised by a reasonably diligent person with both the general knowledge, skill, and experience to be expected of a director and the general knowledge, skill, and experience that the director has. The duty to avoid conflicts of interest. A director of a company must avoid a situation in which he or she has or can have a direct or indirect interest that conflicts or possibly may conflict with the interest of the company. The duty to accept benefits from third parties. The duty to not accept benefits from a third party. Sorry, a director must not accept a benefit from a third party conferred by reason of his being a director or by his doing or not doing anything as a director. The duty to declare interest in proposed transaction or arrangement. If a director of a company is in any way directly or indirectly interested in a proposed transaction or arrangement with the company, he must declare the nature and extent of that interest to other directors. So the duties of directors shine a light on the fact that directors are the heart and soul of the corporation, and as such are accountable and play a major role in achieving good corporate governance. Participation of directors without bias goes a long way in improving the credibility of the corporation, the standard of governance, and the company's risk management. Director accountability. Accountability is often used synonymously with responsibility, blameworthiness, and liability. Accountability is necessary to legitimize the great power exercised by directors of public and private companies and to promote good governance, behavior, and market trust. It is rare for directors to face repercussions from their companies or shareholders or subjected to regulatory sanctions for business decisions that cause harm. As such, the extent to which directors should be accountable for business judgments is often contentious. For directors conducting their duties in a satisfactory manner, as well as maintaining accountability in the midst of the COVID-19 pandemic, has proven to be a huge challenge for the most part.
You have 2 minutes left.
Directors are also accountable to each other as highlighted by provision 13 of the Corporate Governance Code 2018. The code states that non-executive directors should scrutinize and hold to account the performance of individual executive directors against agreed performance objectives. So in other words, the code requires that directors should be accountable to each other and the company in that they have the duty to exercise their responsibility with honesty, integrity, and put the interest of the company ahead of their own self-interest as highlighted in Principle B and Provision 13. Challenges posed by COVID-19. The COVID-19 pandemic represents a true crisis and unique challenge for nearly every director today. The short-term impacts of this pandemic were and continue to be felt immediately and effortlessly due to the widespread lockdown and social distancing measures, whilst the long-term impacts are still yet to be seen, though the expectation is that it will have long-lasting, profound economic, social, political, and cultural impacts. This is due to the fact that the pandemic raised challenges such as liquidity concerns, financial strain, and the move to remote working. Additionally, challenges such as procurement of goods or raw materials to transportation, production, delivery, as well as the human component continue to have to be managed on a day-to-day basis, and the list of operating challenges seems endless. Directors of companies have had to manage the blood life of any business, such as cash flow constraints, working capital. Corporate institutions have switched to safe mode and mechanisms that ensure the interests of stakeholders have been put to the test. COVID-19 and the role of directors of companies. The duties of directors in the midst of a crisis play a critical role in an organization's ability to emerge from the crisis and to push forward into a new era of economic recovery and opportunity for the benefit of all stakeholders. The COVID-19 pandemic and its challenges highlight the centrality of risk management in strategic planning and corporate governance. Thus, a principle of a good director is the ability to identify, assess, and mitigate risks. This should be integrated in strategic decision-making and core business functions instead of viewing risk management as an auxiliary function. Therefore, reviewing and managing emerging risks is a crucial part of how directors of companies fulfill their accountability obligations. Even so, the degree and effectiveness of the director's interventions in order to mitigate the impacts and challenges caused by the COVID-19 pandemic depend on the corporate governance structure, composition, and characteristics of the company, as well as the background and expertise of the director. The COVID-19 pandemic has also helped to further expose the inefficient and weak governance processes deep-rooted in inequality and the lack of social security permeating some organizations. The COVID-19 pandemic has exposed and exacerbated some ingrained social issues such as poverty and inequality. There have also been some concerns that some directors of corporations may be exploiting the catastrophic global pandemic to aggressively meet their pre-existing corporate agenda, including regulatory rollbacks, suspension of environmental law enforcement, criminalization of environmental protests, and direct government bailouts in a growing number of countries. Even underlying risks facing the industry, however, remain unchanged. A prime example of this is highlighted by the growing divide between vaccinated and unvaccinated people, with governments and directors of companies planning, or in some cases, introducing an increasing number of restrictions on people who have not had their COVID-19 vaccinations. Even so, as directors of companies strive to work out how best to keep their companies flowing and their staff safe, they're faced with the challenge of maneuvering the legal system, as the law concerning COVID-19 vaccination is still somewhat unclear.
You may begin to round up.
Okay. This virus has significantly changed the world on multiple levels and led to a need for the remedies and solutions such as the Corporate Insolvency Governance Act 2020 in order to promote urgent imperatives for entrepreneurial transformation. Many aspects of the Corporate Insolvency and Governance Act 2020 were originally driven by a number of high-profile collapses of British businesses. However, due to the current public health emergency, the timetable of enacting changes for corporate governance and insolvency has had to be accelerated alongside the introduction of a new regime to stimulate recovery. However, these temporary measures, though they provide relief and breathing space for directors of those companies which were facing imminent insolvency, the relief and breathing room gives a sense of artificial security. Hence, it is critical for directors to accept the reality that the company may likely be carrying debt and thus unable to regain its financial health in the short term. So in conclusion, the COVID-19 pandemic and its aftermath will test the stamina and the ability of companies and their directors to persevere and to be resilient. The directors of companies will continue to be tested and be faced with difficult decisions, as what they decide today will define their future of their companies. This brings me to the end of my presentation. Thank you for your time.
Thank you so much. Those with questions, let's type them in the chat box. We shall read them all at once after all the presenters in this session have presented. We are moving on to the next presenter. Let us be mindful of our time. We have 15 minutes. We are moving on to Ms. Molife from the Northwest-University, and the title of your presentation is A Legal Analysis of the Use of Online Dispute Resolution to Resolve Company-Related Disputes During the COVID-19 Pandemic in South Africa. Over to you.
Okay, thank you. My name is Lisedi Molefe, and I am a LM candidate from Northwest-University, and my presentation is about analysis of the use of online dispute resolution to resolve company-related disputes during COVID-19 pandemic in South Africa. I'll start by introductory remarks, then define keynotes, and state challenges relating to the resolution of company-related disputes during the COVID-19 pandemic in South Africa, then the concluding remarks. This paper seeks to discuss the challenges relating to the resolution of company-related disputes during the COVID-19 pandemic in South Africa. It also identifies contributing factors to the challenges to resolve company-related disputes. And I'll be discussing how the implementation of an online dispute resolution system will help resolution of company-related disputes efficiently and efficiently. Accordingly, factors such as backlog costs, high cost of litigation, and long procedures of litigation will be discussed. Online dispute resolution is the use of online internet-based platform to resolve disputes using alternative dispute resolution mechanism with the intention to resolve disputes quickly and adequately. Alternative dispute resolution is a set of practices and techniques aimed at permitting resolution of legal dispute outside the courts. It is normally through conciliation, mediation, arbitration, or variety of hybrid processes by which a neutral facilitate the resolution of legal dispute without formal adjudication. Corporate disputes or company-related disputes in a broad sense means commercial disputes between corporation or business partners. And in a strict sense, it includes corporate governance disputes involving shareholders, directors, and company itself. I'll be discussing challenges relating to the resolution of company-related dispute during the COVID-19 pandemic in South Africa. Firstly, I'll discuss the backlog of cases in South African courts. COVID-19 pandemic and the consequent lockdown levels affected everything, including the legal fraternity. Despite courts being considered an essential service since the first alert level 5 lockdown in 2020, courts processes in South Africa had to change and adapt to the new norm. There has been an increase in backlog cases in courts because of the restrictions. There has also been increase of urgent cases. Furthermore, the courts have been dealing with urgent matters, coronavirus cases, certain criminal and family matters, and claims that were about to prescribe. The second challenge is that litigation is costly. COVID-19 has caused businesses to liquidate or get into business rescue due to financial implications. As a result, most businesses do not have funds for litigation. Litigation is expensive for a number of reasons, but the primary reason is that litigation is very time consuming and labor intensive. As a result, most companies opt for alternative dispute resolution as it is cost effective. The third challenge is that litigation can be lengthy, can go for months. Litigation processes can be too long and complex and end up being too costly. There are a lot of procedures and delays which may result in money loss and ruin business relationships. Long processes can disrupt the company's productivity, which could harm future income. The fourth challenge is that alternative dispute resolution facilities are inability to hear disputes due to COVID-19 restrictions. COVID-19 restriction prohibit gatherings and promotes social distancing. As such, ADR facilities such as the company tribunals have not been able to hear company-related disputes. Most facilities are not well equipped to make use of the online dispute resolution. Okay, on my concluding remarks, there needs to be laws implemented that promotes online dispute resolution and the use of artificial intelligence to resolve company-related disputes. The court should recommend online dispute resolution as an alternative to litigation to promote easy and cost-effective resolution of company-related disputes. Online dispute resolution will ensure that companies adhere to the COVID-19 restrictions of social distancing and also resolve their disputes fast and cost-effectively. The ADR facilities such as company tribunals needs to be well equipped with modern technology to promote effective online dispute resolution. Thank you.
Thank you so much for the presentation. We are moving on to the next presenter in this session, and that is Prof. Kloppers from the Northwest University. And the title of his presentation is The Removal of a Trustee Based on a Loss of Mutual Respect, Evaluating McNair versus Crossman and another, and Fletcher versus McNair. Over to you, Prof.
Thank you, Chair. Let me just see if I can get I hope my screen is being shared at this stage. I'm just trying to get it into the display mode. And let me just minimize that part. Is it on the display mode on your side, Chair?
Not yet.
Thank you. So thank you, colleagues, ladies and gentlemen, for the opportunity to present here today. As you can see there, the title of my presentation is about the removal of a trustee, which we were just talking about. Importantly, I hope that you won't hear the word COVID-19 once in my presentation. This presentation deals with the removal of a trustee, where it happened that the trustees didn't play nice with each other anymore. They had disputes, and the disputes were, the questions were whether or not the dispute was of such a nature that the trustee can be removed on application to the court and be removed by the court. So the outline, as you will see it there, I'm going to give you a little bit of background. I'll quickly refer to the setup and the timeline of conflict because it is quite interesting but elaborate, and it will take up quite a bit of